Give it, let us see. Yes, yes.
137. Item number 137. Hearing please. Let
It will be taken up. Why are you presuming that it will not be taken up? My pleasure.
time permit.
If time permits, don't know. Obviously, take it up. In where in the list, I'll take it up.
I am in a similar condition, my lord, if you lordship can you
Get the time, I'll definitely.
can it do 2 o'clock if you lordship? It's very sensitive issue. 2 o'clock, 1:33.
So sensitive, therefore, it has to be taken up after the all the
When serial comes, then that may not.
Then let me see. Let me exhaust the board first.
Base admission matter, I have already filed 2 memos. The urgency involved with this case is that the petitioner is a stable seaman. He works in Navy and he travels to the abroad on sea manner. Because of a criminal case instituted by his immediate neighbor,
What is the offense?
offense matter 323, 294, 506, 34.
When is sailing?
He has to sail to USA.
When is he sailing?
My lord.
When he is sailing, you tell me the date when he is sailing.
He is selling, my lord. He had to sell in the month of October, my lord.
When you file this petition?
Prior to that, my lord.
Other than you waited. But that's right. But where is the overnight urgency? Okay, you give it. We'll see. Give it.
He has already another.
It's all right. You give it. I'll just check it up. I'll check it up. Definitely, I'll check it up. Just see. Huh? I understand it. I'll just check it up. Yes. Not tomorrow. Try to appreciate. How can I adjust like this? If every matter there is some urgency or the other. And whenever you file the petition, you tell me.
1 month before.
1 month before. And today you are immediately coming and
Already filed 2.
I am taking up all the matter depending upon the urgency. We'll see. Okay.
Compromise matter, informant and injuries are present.
Offense?
Offense 294,
I'll see at 2 o'clock. Yes.
Pardon to mention, my lordship, matter offense relates to 376 and 67A. Lordship, it was listed on fixed on 25th October, but due to the cyclone holiday, it could not be listed.
Then it will come on 7th.
My lord, fixed
7th.
Obliged.
Because 25th matters will go to 7th and 24th matter will go to 30th.
Grateful.
Maybe allowed to mention.
Yes.
This is a CRT matter. FIR has been filed by the trustee and for 51 of OMCP is not authorized under that. The matter is ready for hearing, Your Lordship. May it be
We'll
taken.
give it. We'll see.
Your Lordship, I mentioned two matters.
Mention, my lord.
Yes.
Item number 145 in the hearing list, my lord. Very urgent matter, urgent. Every matter is urgent before Your Lordship, I admit, but he is very badly suffering, and this is a case, my lord, of under section 31, where the decoy witness has not supported. It will take 5 minutes.
You be ready. I'll take it up. All the matters I'll take it up. You get ready by 2:30 or so. I think I will exhaust my board and start taking up the regular matter. Yes.
Your Lordship, I'm mentioning two matters. Your Lordship, which pertains to interim compensation under the NI Act. Your Lordship, the time period is till 18th of this month. And we are really under 20%. But we are really under huge financial distress, Your Lordship, and we want to send the matter to mediation.
Generally, I say that pay 10% and go and move up.
We are ready to pay 10%, and rest should be sent for could be sent for mediation if Your Lordship permits us to do so. And for that reason, Your
you just see it can be taken up.
Pardon to make a mention, Lordship, criminal appeal number 525 of 2015. In the meantime, the original appellant has been passed away and his widow wife has been substituted as the appellant. And what happened in the meantime, the marriage doctor of the appellant has been approaching. So I may pray Your Lordship kindly be taken up for hearing this matter. This is on
item
525 of 2015.
Out of list. Is the appeal?
Is the appeal?
It will be included. Yes, give it.
Lordship, if only one has not come. And
Regular matter,
yes,
weekly,
yes.
don't worry, it will come.
Actually, item 170 to this list. I feel that the matter be taken up some other day. Your lordship, Mr.
117, whether I can reach or not, then let us see, it will be, no problem.
Only adjourn your lordship.
It's all right, let it be.
Interim order is taken.
Wait, let me see. I'll see that. Definitely you have not filed, taken interim order. I may vacate it also.
Your lordship, it is the it was already there. Your lordship, but compromise has been done.
Let us see, I let me reach there, okay.
Okay.
Let me reach.
Your loss.
Yes,
Your lordship, item number 122 and 127. It's a similar matter related to two submissions. Then the pending reserve order has come, then it will be taken amendment.
you are supposed to give me the notification, you have not given.
They already given on the next day to, sir.
In which matter you have given?
On the both the matter I have given 2 copies. And
That is Lovicho. Okay.
it will allow another copy and give you.
If you have, you can give me, I'll just go through.
Pardon me, Lord.
I can dispose it up on the basis of this circular.
On this matter.
What hearing? Your circular only. And I have put the circular and dispose it up. Which part? Which relevant part?
I'll mark it out and give you.
Mark it out, just give, so that it will, okay. There is what they are, yes, yes.
Pardon me, Lord, there's a matter.
Thank you. Offense? You tell me the offense, because now the, if POXO is there, then
All
take it up, we will see. You tell me the offense, write down the offense and give.
Another warrant of arrest issue.
Right, but that is better idea. Yes.
Another warrant of arrest issue, 160.
One CC case. There you go. Yes. Warrant, cancellation of warrant. Cancellation of NBW.
Absent.
It's all right, cancellation of NBW. Yes,
My lord, withdrawal memo.
withdraw, yes. Which item, sir?
My lord,
Item number?
not for today, my lord. It is.
Tomorrow, yes.
Belgium.
Yes, let us start.
Item 53.
Item 53 also on behalf of Mr. Sahu, pray for adjournment approval, my lord. It's a compromising matter, my lord. The marriage process is going on, my lord.
Hmm?
The marriage process is going on, my lord.
You have taken interim order saying that you have settled the dispute. Now you are asking for adjournment.
Pray for adjournment. Mr. Sahu is another for
I will vacate the interim order then.
next week, any date, my lord.
See how many days? See, 1, 2, 3, 4, 5 days you have taken.
Last chance.
Saying that you have settled the dispute, taken an interim order. Thereafter asking for adjournment from February 2023.
So give them last chance in next.
I will vacate the interim order. That you will settle or you don't settle. You are making a wrong statement then in the court that you have settled the dispute. If you would have settled, I have been telling you, call them in VC also. You don't call them, taken an interim order and the matters are pending.
Last chance, next week, any date.
Why last chance? Why not today? 2000, just see, 6th February 2023. Thereafter, the matter was taken up on 13 August 2024. Thereafter, 20th August 2024. Thereafter, 23 August 2024. Because continuously after 2 days, I have given because you said that you will bring them. Therefore, 18th, 20th and 23rd I have taken in August. Nobody came. Thereafter, I adjourned it to September, 26th September. Now you are asking for adjournment.
Paper last chance.
No. I'll vacate the, pass it over and I'll vacate this thing.
Pass over, pass.
Pass over. I'll vacate this thing. You tell whoever it is. You have made the wrong statement then. You have not settled the issue.
Pass over.
Yes.
You
You might have taken interim order. No interim order. That's, I've done a good job then. Okay, requisition. these requisites filed belatedly shall be utilized for the purpose of serving on respondent.
চারটা দেন।
Respondent.
এটা দেন।
Yes, finish the matter.
আর ওটা 104 আউট ছিল নোটিশটা যাইছিল 104 রাইট
104 রে
হ্যাঁ এটা নোটিশ যাইছে হ্যাঁ চারটা ম্যাটার ফাইল করতে চারটা ভিতরে তিনটা আছে সেটা
104 দেখিলি
তিনটা আছে
address you can't be located. Press address.
সেটা the wife she will say divorce is
You take fresh notice in any case. These matters are getting urgent. Take fresh notice. And 104 take fresh notice.
104
104.
তিনটা আছে 104
I don't want you. ठीक है. You have to satisfy me. Interim orders are not. हाँ.
498
Yes. You settled the dispute. Huh?
Yes, settle the notice file.
What notice is required? So you have settled the dispute. Bring it. And then settlement is neither.
Settlement is actually.
Settlement is also. Huh?
Notice
Notice
gale na asi boli kosi.
One notice is not accepting the notice.
No, notice not located.
You say that she is staying there.
That is.
And just now, one matter before what had happened, you have seen taking interim order and then keep on asking for years together adjournment. You bring tomorrow. Day after any time you bring, I'll pass it.
I know. I don't look at
Then yes, notice you issue notice and there is interim stay of the proceedings also. It is made clear that if the petitioner will fail to serve the opposite party number 2, the interim order passed today shall be vacated in the next date of hearing. The interim order is passed because the matter is arising out of a matrimonial discord and the petitioner states that they have settled the dispute. Yes. That's the reason I am reluctant to pass interim order. And see, once interim orders are passed, inquisitions are not filed for years together.
Same day I filed.
No,
Same day.
I'm not telling you. I'm telling what is the general thing, what is happening. Anyway, okay. The requisites will try to be utilized for this purpose. 104 is the same order.
Not located really to
That 104 first notice. Huh? Persuade her and bring and that cause it unnecessary. Yes.
55.
And through IO also, huh? Notice through IO. Notice through IO. 104.
Let's see, there are three matters. CLMC 240, 241 and 243. In this, all relates to the same pair, release of the accounts of the petitioners therein. The facts leading to the filing of these applications is that pass over.
Nobody is there, huh? Pass it. Can I just pass it? Yes, pass over. Yes. 56 also. 56 also. 55 and 56 both.
My lords, I may be pardoned, I am on VC, my lords.
Yes.
My lords, offenses are 419, 420 and 66 and 66D of the Information Technology Act. Matter
Yes.
has been settled, my lords. Money is involved, 31,200 rupees.
No,
My lord,
no. What are the allegations? What are the allegations against you?
My lords, allegations is that petitioner number 1 is a banking agent, mobile banking. My lords, while he was authorized to withdraw the money, my lords, on the permission of the victims, he withdrew some of the amounts which he has, which the victim has not been permitted. My lord, suppose the victim has permitted 2,000 rupees. He has withdrawn 31,200 rupees. That is the allegation. After that, my lord, sir, that was returned. That was returned, but technically these are the offense.
Totally, how many people are involved? There are
My lord-
11.
My lords, 11 people are involved.
11 people have given complaint. What about the other?
My lords, only the informant's wife is the major victim. Others are,
Come to page 14.
my lords, your lordships earlier occasion directed to appear the informant through VC. My lords, the informant is through VC.
That's right, maybe, but you come to page 14 for a while.
My lords, charge sheet has been already submitted. Charge sheet has been submitted on 26/9/2023.
My lord, here is the case, my lord, this is cyber crime. And several persons have been treated by this person.
Several means how many that?
Your lordship, as per my record code,
Because page 14 FIR, 14 people have given complaint.
and one
No, my lords, in the FIR, 11 people are there.
1 minute, one minute, Mr.
he has only compromised with one person, my lord. And your lordships know this is cyber crime is the offense against the society.
I know.
And several persons have been cheated.
This has become a very
exact
dangerous trend now.
Exact is not there with me, my lord. But so far this 161 statement of 7-8 witnesses are there. They are categorically stated.
You have settled with how many people?
My lord, sir, the charge sheet already submitted. These cheating is confined to 11 people, my lords.
You have paid to all the 11 people.
My lords. And police also has seized the cheated amount.
Where are they? All the 11 people are here in the VC now.
My lords, apart from that, I have paid the all amount to the victims. My lords, the informant will say everything. My lord.
Taking the money from petitioner submits that charge sheet has been filed on when the charge was filed?
26/9/2024.
26/9/2022.
My lord.
2024.
My lords.
2024. He submits that the petitioner have settled the dispute and paid back the amount he has unauthorizedly withdrawn from the account of the victim, account of the victims. Let the IO of the case verify this fact and submit a report on the next set of a hearing. Release the matter after 1 week. Yes.
My lords, IO has also seized the cheated amount.
Let him give a status report whether all the victims have been paid or not. Let us see. Yes, next. 58, yes. Yes. 58. Password. 59.
It's pretty, lordship.
Yes, sir.
On the earlier occasion, my lordship was directed to file
Yes. Lordships are directed to file the affidavit by the collector, my lord. That is with me, my lord. I am filing this.
Collector.
File. And what was sorted, he has also filed the objection.
But acha. He further files an affidavit by the collector, Raigada, on her annexes, under annexes 3. And what is this matter?
lordship petitioner is the principal of the school. At that time, some student alleged that there is some problem in school and like drinking water and they demand the transfer of the principal petitioner. And after that, collector made an inquiry. And inquiry found that there is no allegation is false and there is a protected allegation against the petitioner. After that, what happened? Additional SP sent this report, allegation petition, allegation of the student and the inquiry report of collector the INC Rayagada in Thailand FIR. And after that, FIR has been learned under a severe section, my lord. 354 IBC 12 POSCO Act and 31 SWI ST. In the Vidhan Petition itself, I mean, intention is commission of the public offense. On that ground, I would make this one to apply that FIR, my lord.
Yes, let us see the FIR. Investigation is complete.
No, my lord, sir.
Let the investigation be complete. How can I? I am filing the.
Yes, case is trial, my lord.
Because I will obtain instruction because.
Charge has been same.
Yes.
Obviously.
Charge is well, it's going to trial, my lord.
Of the victims, my lord.
Yes.
They are come, my lord, by working and we will be collecting. That is text 7 your lordship's hand.
87.
Of that, the
Yes.
affidavit.
Yes. Read it.
ପ୍ରକଳ୍ପ ପ୍ରଶାସିକା ବହୁତ ଉପସ୍ଥିତ ମୁଁ ଏହା ବୟାନ ଦେଉଛି ଯେ
482 petition, counter, rejoinder, on that basis and decide.
My lordship are directed.
You file objection to the you file objection.
My lord, it is collected very forcefully.
Collector doesn't have any, because the criminal case is going on, trial is going on, we have to face the trial. What is this? Who is collector now? Who is collected to do it? If the trial is going on, can the trial be curtailed and parallel inquiry can be done by the collector?
My lordship has power to any stage.
That is what I will do it. You give written submission. That is what I will do. I will just see. To sabotage the trial by conducting a parallel inquiry.
It's my name. That is before the registration is there.
Sir, that is the. Inquiry, so administrative inquiry is in a different parlance altogether for the purpose of departmental. See, 161 statements of many girls are recorded. How will I throw them out? One thing, on the basis of the collector's report, yes, can I throw the charge sheet? Is it permissible under law? No, then if charge has been framed, you are facing the trial. 161 statement of many girls. They will say that you have done all these things. How can I throw them out? Maybe on the basis of a collector's report, which was prior to the fire.
No, yes.
Sir, thereafter the investigation is taken, the trial, evidence is taken, charge has been framed.
Answer one. Please, my lord.
Yes.
Answer one.
Yes, of course. Again, you are reading the FIR.
Answer one, my answer two, my lord. This is answer two, 60.
Yes.
The allegation beating problem, all these things, I mean, we turn the FIR. That is the problem, my lord. Or the विषय itself goes the other को बदलने का अवेलेबल
है 23 my lords. Yes. Order 23 my lords. Yes. Order passed by the Lord and Magistrate on the ground of, what is that order? 48 by your lordship, kindly see page 23. 23. May I permit to place only 2 lines of the order. As it appears on record that the case is of the year 2019 and it has been lingering for evidence from the side of the complainant. The complainant already examined. Where is that order, sir? Kindly page 32. 32, my lord. Okay. Yes. As it appears on record that the case is of year 2019 and it has been lingering for evidence from the side of the complainant. Where are you reading? My lord, order dated 4/8/2020. It said the complainant is absent on so and so step is not taken on. We have only 2 lines, my lord. No step was taken on. Which line you are reading? I am reading 3rd line. Third line, okay.
As it appears on record that the case is of year 2019 and it has been lingering for evidence from the side of the complainants.
Their portions long and difficult in they were peaceful not to register in the program. Except filing some agita and poetry with one. The case is dismissed for non-prosecution. You are the complainant, my lord. You have not taken, just see the proceeding right from your page,
My lord, your lordship,
you see what have you done?
the only steps has not been taken by the
If
complainant.
you don't take the step, 2021 you filed, sorry, you filed the complaint in 2019. See from what is page 27 onwards, you see the proceeding. What have you done?
I have deposed my evidence.
Where is that?
My lord, your lordship, can you see page 20?
Advocate complaint present. Advocate complaint files.
Your lordship, can you see page 20?
So.
Order dated
So.
9/9/2022. And in the meantime also present petitioner submitted a closure memo of the evidence before the learned court below. And also affidavit on evidence also submitted.
What are the offences?
Matter relating to 138 in Act.
I'll restore it. I issue notice. Issue notice to the opposite party. Number 2. Opposite party number 2, written agreement. So ex party I can't do it. Take out the notice.
My lord.
After 1 week will just. No interim order can be passed here. What?
Dismiss event the interim order ki chap. Mane in which manner my states are passing such order that is
Chindi. You should have seen it.
evidence submitted, the deposition of affidavit already submitted and also closure memo submitted. Thereafter such order passed by the magistrate.
Take out the notice. Yes.
61.
Yes, 61.
I am a pleasure, lordship.
Yes, sir.
I am for the petitioner, my lord. Refer question of entire criminal proceeding in GR case number 44 of 24.
76 and all.
My lord.
Yes. Investigation is still going on.
No, my lord. That's what they submitted the petition.
You have not filed the charge sheet, nothing is filed. Except FIR, there is nothing.
मैं इधर और चार्जशीट डाला तो फाइल कर दूँ.
So you withdraw it, file a proper petition. It's not a proper petition.
मतलब opposite party filed an affidavit. Affidavit was no objection.
No, opposite party was not on the rules of the opposite party. See, charge sheet filed for what offences?
417, 420, 376, 2N, 506 of IPC, read with section 3 SC/ST Act.
Here is the affidavit. Rule policy. You have seen the affidavit?
Yes, my lord. But 160% not fully there. Even if let it appear, my lord. It's direct appear. And then
Man simply issue notice, is an incomplete petition. He has not filed anything. You filed all the documents and just issue notice. Issue notice to opposite party number 2, returnable within 2 weeks. Mr. Jana accept notice for state and pays notice.
matters appeared. Filed an affidavit.
He has to appear by filing Wakalatnama. I don't know whose affidavit is this. And she can be also prosecuted because of the affidavit. Just see the affidavit. You are inviting problem for not for you, and you are inviting problem for the informant also. Just see the affidavit, the language of the affidavit. So therefore call her. Yes. Yes. Yes.
Here, my lord, the petitioner has challenged the order taking cognizance on the ground that the complaint has not been filed within the due date. And also no petition for condonation of delay has also been filed in that respect. My lord, may kindly see 138C vis 142B of NI Act. And the facts, my lord, will see. I have stated specifically in the body of my application.
What is the check amount?
Check amount
2 lakhs. 2,20,000.
My lord. My lord, may kindly see paragraph 10.
Yes.
My lord, the
Enough? Oh, yes.
my lord, may kindly see.
Yes.
Moreover, opposite party number 2.
Only 10 of your petitions.
Yes, at page 5.
Okay.
Legal notice was sent on 10/4/2023. But complaint petition was filed on 9/8/2023.
No, legal notice was 18th, sorry,
10/4/2023.
10/4/2023.
And the petition of complaint was filed
There
on
is no condemnation of delay. Where is the cognizance order? This must be there. Nothing.
valid.
Where is the cognizance order?
Valid page 20.
Page 20.
Valid this is correct running page.
Yes, let us come to the complaint. Complaint what ceases. Complaint is filed on
Let's find out earlier. It was filed on 9. No, at the days.
9/8/2023.
Valid. It seems valid.
18/3/2023. March. See, legal notice was issued on 10/4/2023. When it was served on you? It's not mentioned yet.
It has not been mentioned in the body of the application also.
Nothing is mentioned.
Right. Moreover, on 10/4/2023, the complainant had also sent a demand notice. Nothing is there when it was received. And whether there is in delay or
So, Mr. General and Counsel for the petitioner submits that the opposite party number 2 sole opposite party, yeah?
solo.
No, 2 opposite party number 2 alleged to have issued legal notice for the donor of check. Legal notice, statutory legal notice under section 138 NI Act, alleging dishonor of the check issued by the petitioner. Dishonor of the check by his banker issued by the petitioner. However, the complaint has been filed on 9/8/2023 beyond the statutory limitation period. There is no condemnation of delay application enclosed with the complaint. Despite that, the trial court has taken cognizance without even considering the delay aspect of the matter. Issue notice to opposite party number 2, written so and so. In the meantime, the proceeding before so and so is stayed. It is made clear that if the requisites are not filed by tomorrow, the interim order of today shall be vacated.
I instruct him to file today.
Yes. Shall be vacated. And shall I send you to mediation and finish it up 2,20,000 rupees?
My lord, after his appearance only, it will be better.
Okay, next
My
week.
lord, fix up a short date.
Next week. Yes.
And I'll have liquidates by tomorrow or by today. Yes, I will stop.
63.
May I please, Your Lordship? Yes, sir. And this is for quashing of criminal proceeding, particularly the cognizance order under Annex 7 on the ground of pendency of a parallel criminal proceeding. First, fact of the case is, my lord, that Annex 2,
Yes.
that is FIR in Golonthara PS case number 309 of 2023 was filed by the opposite party. Thereafter, on the same allegation, on the same set of facts, another FIR she filed, that is FIR in Golonthara PS case number 315 of 2023. Yes, sir. Then, my lord, kind have a glance over page 79. 79, my lord. Yes. In that case, the police submitted final form stating that ground. Last but fourth line, my lord. As a case has already been registered on the same incident, the same date and time, and on the same complaint, this case is a case of FIR false. 79. My lord, page 79.
Where are you reading?
Last but fourth line, my lord.
Yes.
As a case, my lord, got it?
Yes.
As a case has already been registered on the same incident, same date and time, and on the same complaint, this case is a case of FIR false.
This is,
Yes,
this is closed.
Yes, my lord. Thereafter, again the opposite party
File protest petition against this.
filed the complaint case, my lord. So on the same self allegation, on the same set of facts, my lord. So it is just like a double jeopardy.
The learned counsel for the petitioner submit
can
that the opposite party.
File a petition under section 210 for tag of that original case. The final report submitted.
No, see, there are two cases were filed
Fine.
on the same fact.
Same fact.
One case is investigated and ended up in a final form.
Final form on the ground that another case
And
is.
is already pending. That's the finding.
Fine.
And against that complaint, again files a protest petition.
Complaint person.
So two
Complaint.
things there are to protect this litigation. For Monday lordship.
Yes, I understand it. It can be tagged. But why to prosecute a person repeatedly? Oblige me. Opposite party number 2 initially filed Golondara PS case number 309 of 2023 against the petitioner. On the self-same allegation, he repeated another FIR being Golondara PS case number 315 of 23. After the investigation of the case, the police on what is the date of charge sheet? When is the date of charge sheet? Closer form.
3/8/2020.
Date, sir, date.
3/8/2020.
After the investigation of the FIR PS Golondara police station for 315 of 2023, the police filed a final form inter alia stating as under. Right now, as under. Inverted comma before. As the case has already been registered on the same incident, comma, the same date and time, and on the same complaint, bracket PS case number 309/23, bracket close, comma, this case, bracket 315/2023, bracket close, is a case of FR false. The case FIR false. Okay. Accordingly, the final form has been submitted. Subsequent thereto, the opposite party number 2 has filed a protest petition against the final form. Issue notice to the opposite party, returnable on so and so date, and in the meantime, proceeding in the ICC case number, where is that? 1 of 2024, pending in the court of JMFC bracket R bracket COG, Convenience Court, Barampur, in state. Yes. Oh, bless me.
64.
Made resource.
In this case, Lord Senior Advocate Mr. Vaidas will appear. So let it be passed over, Your Lordship. May kindly take
No,
it
no,
up.
I'm appearing, my lord.
Appearing, sir.
Yes.
My lord,
Yes,
this
sir.
is the 439 and the 239 application dismissed by the trial court. My lord, may kindly take the FIR first. The FIR should have been quashed in the first place. Page 16.
Yes.
My lord, may kindly see the penultimate paragraph.
Who are you? You are the husband.
Yes. My lord, very interesting. I beg to report that on 6/1, my elder brother dropped my sister-in-law along with the minor son, brother-in-law. Next date on so and so, my elder brother went back to bring her back. At that time, her parents intimated that she didn't come home. We are all further inquired into the matter and came to know that she has gone to Bangalore without any intimation. My elder brother lost FIR number so and so and so. So she switched off her phone, mobile, and other things. Well, not even a. This is I am supposed to be allegedly having an affair with the lady, the informant, the wife's brother's wife. And now, my lord, prior to that, is what all is written is that sometime when, how I tortured her, I don't know.
But what is happening to your marriage?
My marriage, my lord, she is sitting in Berhampur and initiating these proceedings. And all the cause of action arises in Bangalore.
You are not resorted to any divorce proceeding or anything?
No, my lord. And she is sitting in Berhampur.
Why don't you settle? Is a matrimonial dispute 498 and all?
Yes, what is there, my lord? No, 498A is also made out.
Mr. Jana, matrimonial dispute, wife and husband unnecessary. Huh?
177, my lord, CRPC is so clear.
You know, early it is settled. It is
Better.
Gosh.
I'll issue notice. Issue notice. I'll send it to mediation.
That's all right. After appearance, my lord.
No, I'll stay the proceeding and send it to mediation. High Court mediation.
Fine, lord. Fine.
Stay the proceeding and you try. If it doesn't happen, you will see.
If it doesn't happen, my lord, I will come back to my lord. My lord, my moot prayer is 177 of the CRPC has been given a go by.
Don't go into merit, you may not have a case. I'm only because it's a matrimonial dispute, you certainly will be.
Yes.
Don't go into merit.
I bow down.
You don't have a case.
Yes.
It's better that you settle. And as it is, you have not filed divorce petition.
Divorce petition already been filed. Yes, sir.
Settle the issue.
Yes.
Allegation, you can see at the end of the day, these kind of proceedings will end up in the compromise.
Yes.
You may present technique only. It's a matter of money now. How much you will pay and how much you will be agreeing to pay. That's the only end of the day. So do it. If notice returnable on so and so. The dispute is arising out of matrimonial discord. Due to misunderstanding, misunderstanding in the marriage, the opposite party number 2 appears to have filed the FIR against the petitioner. On the query from the court, senior counsel appearing for the petitioner submits that he has no issue for trying for settling the dispute. In that view of the matter, the parties are relegated to the High Court Mediation Center. In the meantime, the proceeding before the which court? Proceeding before which court? In GR case number 399/38 of 2020.
Yes.
Isn't it?
938 of 2020.
938
of
9 proceeding pending before the court of which court? Give the particulars.
FGM
Berhampur in GR case number 938 of 2022 state. Yes.
Deeply obliged.
Awaiting mediation report. Leave the matter also. Yes.
65.
Deeply obliged.
D2 by inlet not there for tomorrow. There for tomorrow. But D2 by inlet my lord. And for my
yes.
66.
Yes, madam. What is this matter?
The offense is under section 20B.
She's asking for quashing of the entire proceeding. What is the stage? Nothing is there. And except FIR, nothing is filed.
Yes,
I told you to call the SR to my office.
sir, charge sheet is not there.
How these people are numbering these matters? उसको वो गिरी tell गिरी to come and be. What is the stage? Nothing is there except FIR, nothing is filed.
Yes, sir.
And he's seeking quashing of the entire proceeding. I don't know what kind of proceeding it is. Pass over after lunch, you will dismiss it.
67.
I will receive them.
My lord, the present petition has posting at the hearing, and the matter is settled between information and acute questions.
I am for the opposite party member through the implement. NDPS case also you have settled. Who? NDPS case you have settled.
No, my lord.
No.
Only some suppose 84 to 1906
NDPS FIR.
was conductor
1 minute. Item number?
77.
You then come to the annexure 1. Something else. Okay. Okay. 294.
1992
Yes.
बस मालिक और लक्ष्मी बस कंडक्टर झगड़ा
What are the allegations?
है एलिगेशन में 60 रुपीज छड़े नेला गाली गुलज कला सेटलमेंट छड़े
60 rupees, 70 rupees.
70 रुपीज
The settlement is told. Settlement is told.
मैंने
Whereas
I am for the opposite party number 2, the informant. We have a amicable settlement between us. I am supporting to this, I am giving the.
but where are they? They should be here.
I am, sir.
That's right. I will accept it, but call them at least on VC. Where is the accused? I understand, sir. He is appearing for opposite party. It's all right. Where is the accused? In the quashing of FIR on settlement, the accused has to be here.
मतलब
Bring them. At 4 o'clock. I'm passing it out. Bring them at 4 o'clock. Yes, no.
68.
मतलब and that Jandi matter they
Why are you filing this kind of petition? You know the threat of this. You bring 2 o'clock or tomorrow on VC, let them appear at least.
yes
In the petition, you are not written anything. Engaging on one FIR, you see where quasi. Nothing is there on the court. Joint affidavit is not there. Why are you wasting time? I don't understand. Yes. Can you bring them tomorrow? Joint affidavit, can you file?
yes
These are not clerical jobs, sir. Try to appreciate. You can't throw a slip and say that quasi. There is an FIR. Investigation is going on. You can't file one-page petition and say that quasi. Some joint affidavit, the parties has to be there. These are not clerical jobs.
Lord, kindly adjourn the matter next week. And both parties will be happy.
I will adjourn it, but henceforth I will start imposing cost. Because see, the board is so heavy, you must understand. Don't file frivolous petitions like this. Adjourn. Okay. Yes.
68.
My lord.
You file a joint affidavit to bring them either VC or in person so that it can be quashed. Allegations are not serious. I can quash it, but at least you should follow the procedure. Yes. Obliged. 68,
My lord, may it please your lordship.
yes, sir.
My lord, this is a proceeding under 528 of the new law, your lordship, corresponding to 482 for
Yes.
passing of the proceeding initiated by the domestic violence, initiated by the mother-in-law against the daughter-in-law. My lord, it's very clear that at least
Not particular, maybe even on facts of each case,
this on basis on the facts as stated.
it is always not that mother-in-law only should harass the.
But as the lordship has held in many.
Can be also reverse also sometimes.
My lord.
What is the relief she is asking?
I am
The
praying
proceeding.
due proceeding, my lordship. Due proceedings is praying under 18 and 20. 18 so far the protection order is concerned, it has been winning because she has admitted that I have left since more than 1.5 years.
Yes.
So for 20, she has prayed that I must pay her 60 lakhs. It has no corresponding anything relating to 60 lakhs for what? 60 lakhs for mental harassment. Since my son is senior entering appearance, I am.
Sort of feeling and submitting that I'm entering my
I
application.
will solve the copy. That is, I am not disputing.
While she was in my rented house, she had removed all the costly valuable articles to another flat and thereafter shoulder. That will be decided.
If that is true, your lordship.
Okay, you enter appearance.
If that is true, my lord. 498 my case has been charge sheeted, wherein police says that my gold and silver ornaments are kept by them. For them, they are charge sheeted under 406. This is my charge sheet. My case against her. She is charge sheeted under 406 for keeping my gold and silver ornaments. Thereafter, she came with a domestic violence petition that I have kept her ornaments.
What is happening in that 498?
That is going on, your lordship. They have appeared after note to charge sheet. They have entered appearance.
What is happening to marriage?
Marriage, your lordship, the husband has filed a divorce. Proceeding, it is going on.
Settle the dispute, right? I wish
That is exactly, your lordship, we are discussing.
I'm sharing it to mediation.
No, your lordship may not send it to mediation. There is some difficulty.
What difficulty you tell me?
Difficulty, your lordship.
Created by the lawyers or
Difficulty is that, your lordship, both the parties are at daggers drawn. So once in mediation, when they came, there was some dispute. They took a different color. So,
Easy they can appear and do it.
your lordship,
If they appear, they may fight.
my lord.
We see how they will fight.
My lord, I have talked with pre-learning senior also, but I'll try it myself. Yes, yes.
He is existing now.
My lord.
A large experience in life, he can settle this. Okay, give a copy.
Only your lordship may permit me to seek an adjournment in the court below. That I have also discussed.
Mr. Mishra, Land Counsel for the petition permits that he will move an application before the trial court for seeking an adjournment. Please the matter. So, yes.
That may be granted. The adjournment may be granted.
Yes, next.
Obliged, your lordship.
69.
69, may I please, your lordship?
And I also enter appearance, also appearance.
69, may I please, your lordship?
Yes, sir.
So 2017 incident, my lord, the petitioner there is challenging the rejection of the discharge petition on 38/2024 at annexure 4. My lord, my only problem is that I am not able to initiate any compromise because it was a Durga Puja in 2017. While in that traffic, there was a duty officer. He was that time training as an SI of police. He collided with the car and not very fast also. He was reversing the car and he was behind. But due to fear of police, the petitioner escaped. He got afraid and he left. So the informant here is himself the trainee. At that time he was trainee. We had his address and everything, but he has been subsequently transferred. So the opposite party informant is the state only. If my lord will,
Jyoti Ranjan?
Jyoti Ranjan Parda at page 7, at page 7, my lord.
No, he is working as what?
I Sri Jyoti Ranjan Parda, cadet of SIF Police Civil. Now on the training of PTI by the now he must be placed. Now he is an officer. But he,
Sir, opposite party number 2 to the IO of the case. Sir,
but his address has to be found.
let them settle. Yes. We will settle it.
Oh, my lord.
There is
My lord, we'll try.
issue notice to opposite party number 2 returnable within 1 week. And the IO of the present case. Who is the IO?
My lord, the Thana was Bidanasi police station. That time it was Bidanasi police station. But that there he was training as an SI, sub inspector.
And now what case is registered in which police station?
Bidanasi, my lord.
The IIC Bidanasi police station directed to serve opposite party number 2, who is stated to be a police SI.
Police SI.
Now, police SI, who was at the relevant point in time was a trainee. Was a trainee. He must be trained, yeah, full circle. Yes.
My lord, any decision on the IO or trial?
You move an application. Your application. Yes.
70. Like first of the cognition of view of compromise, my lord, they have filed the joint action, my lord. All the petitioner and all are present, my lord.
Yes.
I'm for the informed.
What are the offenses?
Offenses 307 and the other thing 360 actually.
Well, I show me the injury.
Injury is the medical, one is simple and one is grievous, my lord. That is the all part, my lord.
Where is that injury report? Where is the injury report?
Yes.
Yes, madam?
Yes.
No, sir.
Have you checked the injury report?
Yes. Yes.
I'm just passing it over at 12 o'clock. I'll take. Just check it up. Check the injury report and which part of the body and what are the weapon used. Okay. And who is the injured? Injured is that?
All of them.
No, who is the injured?
Vikram Pradhan.
He is not included here. In 307, if you want to settle, injured has to be a party. Where is the injured?
If I have implemented the informed.
No, injured has to be a party. I want to see him physically. I don't know what kind of injury he has sustained. He may have an objection. He says, I am the victim. I was beaten up. Who is Ronkonidi? Who is Ronkonidi? No, his father of the victim. Who is he?
The son is the victim.
Who is Ronkonidi?
Ronkonidi is an informant, my lord.
I understand informative. What is the relationship between Ronkonidi and the informant? Injured.
Injured is the another person, my lord.
Then you have to include injured. Injured's consent is also required. You bring him tomorrow? Injured?
My lord, they may be dispensable or the petitioner.
No. They were beaten up someone. Why sympathy for them? Why sympathy for them? Beaten someone. He might have died also. 307 case. Why sympathy for these people? You tell me. Why can't come? They can't come tomorrow. You are also coming every day. I am also coming every day. Let them come. 307 and see the allegations.
Allegation
And all.
particular son of the
Whatever, the allegations are serious. If are quashing, it's all right, no problem. But the injured has to be there. Injured has to be there. What is the injury?
So there is two injuries. So one is simple, another one is grievous.
Grievous where? Which part of
And then
the
for
which part of the
part of the lower
which part of the body?
normal, like that is the
is between upper part of the
Injury.
arm, your lordship,
Upper,
and second hand lower part of the
but
and the palm, your lordship.
half service.
What is the offense weapon?
Weapon of offense, your lordship. Sharp weapon, your lordship.
What is that?
By sharp weapon, your lordship.
What is that recovered? Only four. Just check it up, huh? Just check it up.
Yes, sir.
Can you bring him 2 o'clock, 3 o'clock?
Bhanganar area, my lord.
Online, you ask him. I'll just pass you. Online, if he can appear, I can just. That's true.
Lots of money, right?
It's very dangerous. Sometimes the victim may move an application saying that I was, behind my back, this has happened. Yes. I'll put treated
Monday, my lord.
Monday, okay, solid. Monday, no problem.
Or will be present, my lord. They will be present in the ASCA court, my lord, video conference.
See the paraphernalia. Why are you being sympathetic for these people? I think
There are 14 numbers.
it will be 1,000 in number, but
But if they appear before the, if it's through that manner, then the virtual mode, might be some problem.
so let them come. Let them come. They should feel the pinch of it, at least. And victim also, you will plead the victim. Huh?
And
Monday.
one thing I like to tell also,
Yes.
and that also, so far as the informant is concerned, my lord, he is disabled. He is present today.
Who is the informant?
Yes, you know, that the.
Mansanadi Behra.
The informant is disabled. Informant is
Only Vikram Prathan, my lord, will appear.
Victim will appear and informant is dispensed with and get ready to pay heavy cost. Okay. Yes.
71.
Monday.
Monday.
Lordship.
Right, please, your lordship.
No, make it Tuesday.
19.
19. Okay.
May it please, your lordship. Now the petitioner is seeking passing of the criminal proceedings in city case number 1539 of 2023.
Yes, sir.
My lord, the offences, charge sheeted offences are under 363, 120B, 374 of IPC.
Yes.
My lord, the matter has been settled, my lord. Settled in the sense, the informant initially lodged a FIR that her child has been kidnapped, my lord. Later in the investigation, it came to forth that the husband of the informant had only planned to enter kidnapping scene. The story goes as such, my lord, this informant was initially married to petitioner number 4.
Informant was married to?
Petitioner number 4.
Okay.
She left him and married petitioner number 3.
Okay.
A child was born out of their wedlock of petitioner number 3 and informant.
Yes.
Later, petitioner number 3 got to know that the informant had prior relationship with petitioner number 4. Thus arose the disputes between them. So petitioner number 3 planned that if he'll get rid of the children, the informant will also leave him. That's why he contacted petitioner number 2. Petitioner number 2 gave information about petitioner number 1, which is a childless couple. The petitioner number 1 they were a childless couple, and they had in fact registered before CDMO in 2018 for adoption, my lord. They were in need of a child. The petition number 2, 3, 4.
Child was kidnapped and given to.
Understand the given. Petitioner number 1 had no knowledge that that was a kidnapped child. He was represented that it's a child the parents are willingly given in adoption, my lord. On the same day, the child was rescued. On the same day, child was rescued. Later, all these petitioners have apologized before the informant, and the informant is now staying with the petitioner number 3, the second husband, along with their child.
In this case, I am asking for the
Informant. Why are we settled now?
Yes, my child has been rescued. Now we are staying happily.
What is the you are married to 4 now? 3. You will continue relationship with 4.
No, please.
4 was the first husband. She left her first husband and married 3, my lord. Now she's staying with 3, and the child is also staying with them, my lord.
Capital A. P70 capital A or what is that?
374, my lord.
P70.
Subsection 4, my lord.
Any sentence. What do you say? 10-year sentence. Do you have any judgments to support the case?
I will, my lord. Can we
Find out some.
Because nothing remains, my lord. The child has been rescued. They have also said that.
That's right, but case is on your own admission. 374, section 370, clause 4 is made out on your own admission. And that is an offense attracting 10 years sentence.
I'll provide the.
Just check it up and tell me. I'll just issue notice. least the matter on sunset. The letter counsel for the petitioner submits that the parties have settled their dispute. So and so and its appearance. Least the matter on sunset. Their presence is also required. Ensure that they are present. All of them.
Right.
They are present. Informant has already filed an affidavit dated 29/10/2024. Reiterating her stating therein that she has settled the dispute with the petitioner. Issue notice to annoying. But release the matter on Saturday for a day. Yes. In the meantime, the learned counsel for the petitioner is granted liberty to move application for adjournment report to the trial.
In the meantime, proceedings may be still.
Yes, I have given that. Yes. Okay.
In challenging the order of formance on the ground that the magistrate has not taken causing inquiry under section 200 and 202 CRPC law. Second, the conducting counsel who has conducted the case, he himself cited as a witness in the complaint case law.
Yes.
Your lordship can have glanced the
inquiry was not conducted.
Yes, Lord. Only he has filed the initial deposition. And
show me the cognizance order.
Kindly say, I'm not sure.
Yes.
Annex 2, my lord, page 72, Lord.
Cognizance order.
Cognizance order, each Lord, each annex. Annex, my lord.
Is 76. Annex 3.
Lord, annex 3, Lord. Page, my lord, page 79, calendar. Reading the complaint petition, the statement of the complaint under section 202 200 CRPC, statement of witness to move to CRPC, the document filed by the complainant found that there is a prima facie material under section so against the accused so and the cognizance of offense under section so is taken.
Where are you reading?
Page 79.
79, 80.
And 80.
Okay.
Yes, what is wrong in it? My lord, kind of glance prior to gone through the order sheet, my lord, kind of glance the page 72.
22.
Yes, my lord. Annex 2, relevant pages, page 72.
Yes.
Initial statement of the complainant under section 202.
Yes.
That my name is Dr. Asaf Mohammed. I have filed the present complaint petition against
the initial statement in shape of affidavit. Yes, affidavit is filed. Yes.
But he has not, the magistrate has not inquiry and he has not conducted.
Inquiry 202, inquiry
only the
recorded.
Initial deposition only he has filed that.
But that is there, but inquiry, the same witness may not be again required to be examined. 202 inquiry has been conducted. That's the order. And the lawyer has deposed.
A lawyer who has conducted the
that he should not have done it, but there is no legal bar.
Yes, sir, there is bar.
Who is that?
My lord,
professionally he should not have done it.
Yes, sir.
A professional misconduct maybe. That's a different story.
But the person who has conducted the case,
how is the legal bar from me?
Right. It is. I have taken my ground.
In the ground, no. In the legal bar in the statute book. Show me.
Lord.
Statute book in the CRPC, where is the bar?
Let's say rule 13 chapter 2 of bar council rule.
That is he will face it. That's what I'm saying.
Section 126 of evidence act.
Maybe Mr. Knight, but answer evidence act you show me if you can show me then I will.
That is the what is the communication
is conducted, but in so far as the 202 inquiry is concerned, it has been done. One witness, the competency of witness and whether he is misconducted or not, that is a different thing. You proceed against that lawyer. Proceed against that lawyer saying, you lost your lawyer, why are you deposed? Evidence check to tell me.
126 lot.
126.
The communication between the council and the privilege communication.
That's again misconduct. You can prosecute her. You can very well initiate a proceeding there in bar council. That his evidence can't be thrown out.
Your Lordship, can I adjourn to any other? I will cite a decision.
What decision? This is fast principle. What decision is required in this?
The same council cannot adduce evidence
for the that. Therefore, he can be. You can proceed against him in the bar council. Tomorrow he may withdraw the Mokaratnama. I say that since I have deposed, I will not contest. Who knows?
He has a role as in this case, he also appear for the informant.
That's right.
Present case also.
I understand. It's completely misconduct. I am agreeing with you. 100% misconduct. There are direct judgment on that.
Yes.
Rajendra Gupta versus State of Punjab. Just check it up. Rajendra Prasad Gupta. Direct judgment. But in the same time, you can't throw away the evidence of this witness.
I will gone through this.
But when any evidence and there is no bar.
That is prevalent communication is there, so that
that's right. I'm saying that therefore the privileged communication you can't go and depose. What has transpired between you? Suppose a murderer comes to you and say that yes, I am murdered. And tomorrow you can't go and say that yes, he came and expressed himself completely to whom a lawyer. That's completely unacceptable. But at the same time, you can't throw away. You can proceed against him. You satisfy me with that. Okay, I'll just I'll simply adjourn it after 2 weeks. Lease it after 2 weeks. Yes.
73.
Challenge the communist order, my lord. Right, unacceptable. And case claim, my lord. 224, 294. But public has taken both of them 376 to 447, 341, 320, 294, and 334.
Yes.
The petition is ready, my lord. A prior clause, as you can see. Annex 2, my lord.
Yes.
Offense 371, 294, 341, 323, 34 IBC. Allegation against the petitioner, my lord, is that ଅବୈଧ ଗାଡ଼ି କଲା ଆମ ହାତକୁ ମୋଡ଼ି କାମୁଡ଼ି ଦେଲା.
You want to say that these offences are not made out?
Yes, sir.
Then you argue at the stage of charge. I'm giving that liberty. Right up. Petitioner challenge the order dated 28/1/2022 passed by the JMFC Lamtapur in GR case number 49 of 2021, whereby cognizance of offences punishable under section 376 2N oblique 417 oblique 440 341 oblique 323 oblique 324 oblique 34 IPC has been taken against her. Counsel for the petitioner submits that the charge, the allegation made in the charge sheet and material form part of the charge sheet, even if it's accepted to be true, no case under provisions under section 376 2N is made out. I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to raise all the point and issues before the court below at the appropriate stage. This resolution, the petitioner dispose of. Yes. Yes, I'll just come.
The charge sheet, Your Honor, the learned lower trial court issued summons for appearance of the three of the accused. One is the husband and 2-3 are the parents-in-law.
Yes.
On receiving the notice, when all three filed a petition under 205 on the medical ground, out of three, only the father-in-law was granted bail under 205 on the ground of medical. And a different standard was used because the ground was common to all the three. The mother is suffering from arthritis and the husband is suffering from depression. Due to different proceedings possible under the Act, a wife can avail, has been filed and he is under depression. So why, sir, only father-in-law is granted bail under medical, why not others? The grounds are same. And the ground, Your Honor, I would highlight what is the ground of rejection. It is only the case.
No, what happened to the petition number 1? He's 34-year-old. Why can't he appear? I can understand the senior citizen the petition 1 and 2. What happened to petition number 1?
You Honor, I have filed. They all are on the medical ground. And Your Honor,
Dr. Harinder Singh is 34 years old, and you say that he is suffering from depression and all.
Yes,
Where is the depression certificate, medical certificate?
Your Honor, it has not been disputed by the state. Neither the court.
You showed me the certificate. He is suffering from depression.
I can produce it. Yes, Your Honor. I can produce it in the lower court.
No, you repeat the application. Where is the application, sorry? Where is the application? All the accused cannot be, exempted from personal appearance.
Your Honor, I have also relied upon the judgment of the 1918 Supreme Court, where only on the ground of distant press the bail has been granted under 205.
No, in the application, just come to the application.
Yes,
So, insofar as the petition number 1 is concerned, where have you said anything? Nothing.
Page 23, Your Honor.
Yes, I am there. Ready?
Page 23, Your Honor.
Which paragraph? He is a doctor by profession.
Yes, Your Honor. This is my petition under 205. Page 23 and extra 3, Your Honor.
Where have you filed document? Nothing. No document is filed.
Yes, sir. I have not filed the document, but it was not disbelieved.
Trial court is not filed. And you refuse the application along with sufficient document. There is no
I may be given time. I will file the certificate.
I know. The petitioner is agreed by the order dated 21/6/2024, whereby their applications under section 205 CRPC has been rejected. The petitioners has moved application. Petitioners have moved application under section 205 CRPC inter alia stating as under para 3, page 23. Page 23, para 3. However, no medical document was enclosed by the petitioner to substantiate the claim made by them. The learned trial court has rejected the application. Hence, the present petition. I have produced the record and found that indeed there is no supporting medical document filed by the petitioner along with the application under section 205 CRPC moved by them. In that view of the matter, I am not inclined to interfere in this matter, as no legal infirmity is found in the impugn order. However, liberty is granted to the petitioner to move press application before the court below, enclosing a relevant document to substantiate their case. If such application is moved, then shall be considered on its own merit. Yes. Next. 75.
Please, my lord. My lord, I'm challenging the criminal proceeding which was initiated in the year 2013, my lord. 2013, my lord. The case is, my lord, based on the letter of the transport. What is the case? Same case, my lord. It's a, my lord, based on the letter of the transport commissioner, FIR was registered in the year.
Charge sheet has been filed?
No, nothing, my lord. And it was, madam,
2013.
besides, my lord,
The offense is 408, 409, 34. Charge sheet has not been filed.
my lord, may I permitted 1 minute, my lord. That was registered in the Koraput police station, my lord. After 1 year, it was transferred to CIDCB. And it continued in the same GR case number of 2013. And it was registered as a 3 of 2014 in CIDCB. Thereafter, my lord, the same is at this same stage it is now, my lord. And we are harassing.
Let us get the status report. Learned counsel for the petitioner submits that though the FIR was registered on 6/4/2023, as yet the
it was re-registered. I can initiate.
Okay, as yet the investigation has not been completed and charge sheet has not been filed. Issue notice to opposite party number 2 written within 2 weeks. Okay. But you are on bail?
Bail, my lord.
You are on bail. Okay.
I am, my lord.
I am for what? I can't say. Yes. That's what I asked. If you are not on bail, then I can pass an order for no court bail. Therefore, yes. Yes.
76, 77.
Yes.
76.
76.
2 p.m.
2 p.m. What is that, sir? Yes. Then right now they are there. Yes. Okay, 76. Let us do it. There. 76. What are the offenses, sir? Means
Has been done right by the present.
She was on the road. I took her to the King's Hospital, admitted there for 2 to 3 hours only. Her vehicle, scooty was with me because my house is quite nearer to King's Hospital. Everything was right. On 20th May 2022, the deceased reached at my house and asked, took the vehicle from me. What happened, nobody knows, only God knows. And she immediately fled to Hon'Ble Beach. Thereafter,
suicide note, anything?
No, nothing is there. Even if the primary.
She committed suicide.
She committed suicide. Yes. She is admitted.
What do you say? I think his case is covered by my judgment. I have passed a judgment. Same.
That is the most historic judgment of India. Even if you start from Swami Prahlad Das judgment, that your judgment, Lordship's judgment, Priyanka Tapuri has covered all the cases.
I think he's covered by
the case also. So the present petitioner and approved for this honorable court against the rejection of under section 227 CRP also. This honorable court means verifying and going through matters and record not intend to discharge the present accused petitioner also. Can you this order also?
That I have also.
I think my OP to bring the notice of the court regarding when the court is going to the entire matters and record and not anything. Yes, your WhatsApp. But if the case is
already burned your fingers.
No, Lordship, but at that time it was only to discharge me.
That's right.
It was in a very hurry.
The problem is now you have moved 482.
Yes, Lordship.
You moved the application under 227 before trial court which is rejected.
Yes,
you came before this court while filing a criminal revision petition.
Yes, Lordship.
Criminal revision petition the High Court has dealt with it. Coordinate bench has dealt with it and dismissed it on merits. If I allow 482, either by relying Tapuria, whatever.
Yes, sir.
And he's tantamount to review this order. What can I do?
There the prayer was different.
Maybe I understand. Don't repeat it. It's a tribunal for discharge. This is for watching. But the fact remains on merit. A coordinate bench has delved open the issue and passed an order. How can you get over? Because you had burned your fingers like this. You challenge it and say that I am covered by Tapuria and before the, right court, that.
There was no time, Lordship. At that time, the day on which I was supposed to be charged, the previous day it was listed before this honorable.
See, now you have to get out this order. On merit it is said. What to do?
Lordship, then
I will simply say that you withdraw it to respect to remedy available to you.
no, Lordship, but
Challenge this order. What to do? I can't help it now. You are directly covered, I'm saying.
yes, Lordship.
In my judgment, you are directly
Yes,
covered.
Lordship.
But the fact remains that you have already burned your finger by approaching this court. You file a review, then whatever you do, may open that judgment. You have to get this order.
Allow me 7 days time so that I can submit one judgment of Honorable Apex Court in which I will be relieved from this court.
Can you change this fact scenario?
No.
You can't change the fact scenario. You can't change this order. You can't change the judgment pathway. You can't change the facts up to this case. So this will be after 7 days also. So you resort to the remedy, you withdraw and resort to the remedy. My recording. The petitioner has invoked the inherent jurisdiction of the court under section 4 CRPC seeking classing up for the entire criminal prosecution initiated against him. The allegation against the petitioner is so and so. And counsel for the petitioner submits that his case is directly covered by the judgment of this court in Priyanka Tapuria so and so. At this stage, the counsel for the state has pointed out that the petitioner had moved an application under 227 CRPC before the trial court seeking discharge from this court, discharge from the case, which was turned down by the learned trial court. Against the said order, the petitioner approached this court by filing criminal revision number 187 of 2024. The coding advance of this court by 4/9/2024 disallowed the revision petition inter alia recording as under para 3 and 8. Para 3 and 8. Prima facie, I am for the view the petitioner is factually covered by the judgment of this court in Priyanka Tapuria so and so. However, regarding the fact that the discharge petition filed by him has been rejected by the trial court and which is confirmed by the coordinate bench of this court, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to resort to remedy available to the matter.
Deeply
Yes.
80.
This case, petitioner while working as a tuition faculty in a private tuition company, due to dispute payment of the salary, the administrator of the institute lost the affair in the year 2015. Thereafter, the charge sheet has been filed against the petitioner under section 448, 341, 343, 386, 506 of 5.
Yes.
The trial has been started. In the trial, the charge sheeted witnesses are not found. Even the complainant, though someone has already been issued thrice, she has not appeared.
Yes.
The petitioner, while working outside Canada in Wipro company, due to this criminal case, came to the Odisha and faced the trial, lost a job, could not left the Odisha. Therefore, he filed an application under section 256, though the petitioner has to be filed under section 249, but by giving a wrong provision, 256 has been filed.
Yes.
To discharge him as the complainant was absent, all charge witnesses are absent, prosecution did not produce any evidence. His application was rejected under annexure 1, page 10, by the order dated 4th July 2004.
Yes.
Only stating that no witnesses are present, but page 10, order dated 4/7/2020.
Yes.
No,
And
the regime only assigned no witnesses are present for the defense files a petition under section 256 praying for acquittal of the accused person, submitting that the witness have not turned up despite summons and the summons have been written answer being stated that no such persons are residing in the given.
the power vested with the court under section 249 pass appropriated. As the petition proceeded on provision, the petition has been rejected.
You repeat another application. And repeat another application. Because otherwise also I can target the trial and finish it up. That's the better idea.
But
Because the witnesses are not turning up.
what happened, we have insisted the court to issue coercive action,
What is it?
coercive measure for procurement of the witness.
And the petition is in file, understand 257, 6 year old, so if it's like 6 year old.
Let him have that petition. The petition is agreed by the order dated 4/7/2024, passed by Lieutenant JMFC LR Bhubaneswar in what is this in CT case number 903 of 2015, whereby his application moved under section petitioner in his application contended that despite he has been suffering when the FIR was registered, he has been suffering the rigors of the prosecution since 2015. Despite repeated efforts, the witnesses are not turning up. Therefore, he sought an acquittal. The Lieutenant Trial Court rejected the application on the ground that the application is filed under the wrong provision of law. Hence, the petitioner is aggrieved and has filed the present petition. Then, counsel for the petitioner seeks to withdraw this petition to repeat the application in the right provision of law before the trial court once more. If such application is moved, the same shall be considered on its own merit. Okay. With this liberty, the petition is disposed. Yes. And it is expected that the application to be moved by the petitioner shall be dealt with on its own merit as expeditiously as possible. Yes. Next. 82.
My pleasure, Lux.
Yes, sir.
Finance LLC for on-sale of residential house. For on-sale of residential house. Or on-sale of residential house.
Additionally. Tell me the fact. What is
the allegation is that the principal accused and co-accused are manufacturing the duplicate automobile product and selling in the market. And in this regard, a FIR was lodged by EIPR institution in Pistol Police Station on 2 July 2024. Subsequently, the principal accused and her family members are present in her brother-in-law's marriage.
Whose house is that? Whose house? It is your house.
Yes.
You are the accused.
Yes.
And why should it be sealed?
Actually, the problem is that the family members of the principal accused are absent on this time, and the family member of the principal accused are attending her brother-in-law marriage ceremony. It was lodged on 12 July, and subsequently, without
what is it says now? What does it say? That is not right.
And the principal accused co-accused released on bail by this coordinate was on that let
charge sheet be filed first. Let us see.
Well, the residential house, family members are suffering and staying other provinces.
What is
it? Contrary.
The R1 which is annexed, there are so many plots are there. The facts in the residential house in his plot situated in the fair,
there is nothing.
That were not mentioned. So far, that
the type of petitions are being filed. You have to research out of everything. Nothing is clear.
That's why I have mentioned the corporate number.
Yes, I am online.
The residential house is very close.
So many plots are there in
all plots. I have
petition where you see that which house? In the petition for me.
Let's put para three.
Yes. That is petition number 317. And remove the
Other product.
no product.
This is the number of ROI also. That said ROI, 6 numbers of plots are there. One was the verbal residential plot. And under two, you have to this is a double story building or single story building, double story building. Whenever you say that, nothing is there. Residential property.
Residential house.
But you have to say, it has to be treated properly. Wherever you say that you are staying there, you nobody are saying, no, it's a dilapidated house or what, I don't know.
No, you lost all the time. The family members are absent. Then if you are attending her family member.
Where is that? Where will you say that?
Where already mentioned.
Where will you say? Where will you say that that's a delivery? There is delivery, that is a delivery unit.
You not see para three. Which approach?
Entire case is para 3 only.
Yes, yes.
Where will you say that?
Second one, the family member of the principal liability, including her father, has going to attend her brother-in-law marriage ceremony on 16 July. The family member of the
Notice, yes. Yes. Next.
Okay.
83.
Not a public software. Have been entangled in this case. On the ground that he was lost to the contract. Yes, the challenge is in initiation criminal proceeding, as well as the consequential order of conclusion. Yes. The three ground numbers are very matter. And also in the charge sheet, it is held that no laws have been launched to the government. It further reveals that in the charge sheet, the works executed by the petitioner is not found to be substandard. Therefore, the petitioner, who is a private person, initiation such proceeding is regarding law. This is my ground.
Passing about the charging itself. Yes, you go. If you are so confident about charging that it will be your favor, that why for people that when it is an exhaustive investigation, just see.
Once he has done nothing, why he will be prosecuted?
I don't know.
That is at that.
Well, regarding the charge sheet, what I would like is, it is he gives an opinion kind of thing. On that basis, I can't decide the case. You have to see the document, you have to see the other material placed before the on the charge sheet. Merely, these are the suppose all the materials are fine. Once which you have statement, everything is fine, which are against you. But in the charge sheet, the police write that he is a gentleman. Can I remember that? Doing all the generally, you know, what kind of English they write. Many of them they write whatever they want. Nowadays, at least seniors who rescue and all, they are waiting to charge it. So therefore, you will find it properly. Otherwise, it was all the documents. But the relation of the fact is, we write whatever they want. That is not the basis on the petition was not an act. You argue that marriage submit marriage for the record on and not in the prevention of corruption. How can you do it? You make reasonable bail and do. Are you on bail? Are you on bail? You are on bail. What best you want from this proceeding? Tell me. Except passing. Except watching whatever you want, I am giving it. I am giving you liberty. What? Then counsel for the petition seeks liberty to withdraw this petition to read all the points before the trial court by moving appropriate application for discharge. If such application is good, same shall be considered on its own merit. Okay. With this liberty, the petition is disposed. Even when application is discharged, yes.
84.
Yes, sir.
The discharge petition filed by the petitioner has been rejected by the Lawrence petitioner. And the now kind of glance the date of events is very important.
Yes.
There was lack of sanction in this case.
Yes. Who are you?
Well,
You are
I think that under section 32 reduces 31 years.
yes.
Well, kind of as the dead chart.
Yes.
Dead chart is very important. Right?
Date that you given this?
No, dead chart in the
Okay. Yes.
on 12.2.
What is this you have given then?
But the including FIR charge sheet, because if it will have the
Let us go to
report section.
yes. Let us go to the date chart.
FIR was registered on 12/2002 and 15/2002, accused was removed from service. On 30th January 2004, accused was reinstated in his service. On 25/3/2004, charge sheet was signed. On 13th February 2004, charge was submitted before the Lawrence Special Vigilance Summary. On 25/2004, Lawrence Special Vigilance Summary took cognizance of the officer.
Yes.
Then kindly come to the my note filed by before the Lawrence Special. That is very important.
What is that?
And I will call it. Case 20.
Written note, yes.
Yes, ma'am. Case 24.
28.
24, madam.
Written note 20.
No, written note
Yeah, written note is 28.
28.
Yes.
Written note of copy of it. There is answer for answer for page
28.
28.
Yes, come to. Yes.
Madam, the 28 towards bottom line.
Yes.
The affair of this case was lodged on 12/11/2002. The I was stated in the final form that the accused was then removed from his service on dated 15/11/2002. The accused was had the copy of order number 190/establishment B dated 30th January 2004, passed by artist Nandar Sonpur, reinstating the accused to his service, which is admitted by the prosecution in its objection to the discharge file. Admitted.
What do you want to say? Because you are reinstated, therefore you discharge.
That is not one sole ground. That is not sole ground. On the date of I am coming to it. On the date of charge sheet was filed and the cognizance was taken, I was in service and sanction was necessary. Okay. Coming one by one, I have given the
sanction they have not taken.
Madam,
they have not taken sanction.
They have not taken sanction. I know in one evidence in para 47.
When the cognizance was taken? No. 1 minute. Cognizance was taken.
20th 5/2004.
20th 5/2024 and
2004.
On
30th January 2004, accused was reinstated in service.
Yes, what do you say? Cognizance is bad. That's what he says. He says that on 30th January 2024, he has been reinstated. He was in service. Since the cognizance is taken on 20th May 2004, that time, since he was in service, cognizance could not have been taken without sanction. That's what he says.
Permission not to answer this particular query of but before I page 8 of the petition. If the lordship permission, I may request my law firm to correct the prior portion. The prior is this order is being implemented 24/10/2024 by these dead lots, by which his application of discharge was rejected. But elaborating the body, the cognizance order, that's not the cognizance order. Cognizance order was taken in 2004.
Yes, that is not challenged. That's what you are saying.
That he has to correct.
Why are we not challenging that order?
Well, I mean, pardon, madam.
The cognizance is bad according to you. You should have challenged it. You allow the trial court to proceed further.
But I mean, pardon, madam. Challenging the discharge petition, I have filed. challenging discharge petition. I have had. That's why I have written.
And the discharge petition, you have taken the point.
I have taken.
To me.
That is so good.
To me.
Yes,
I am there. I am there.
that why that the case was para 2 matter. Case 24 matter. Understood? That the case was initiated on the strength of an FR laws and registered on 12/11/2002 on the report of the IO who had been examined as 2022. That while submitting the charge sheet final for after investigation on 25th, the IO has specifically mentioned that he did not feel necessary to obtain sanction for prosecution on the ground that the accused was removed from public service from 15
I think he is a case, sir.
Because
He is a case.
if a lordship permits,
You
if lordship permits not, the first was building notes. On records note, that's once, I know the lordship must that was lordship on the page 11. Page 11 of the placement notes.
Yes. Yes.
Second line placement notes.
Yes.
On that day, I had submitted a written report. So against the lordship, the petitioner, senior clerk Padampa Prasad, who was holding the post of senior clerk, that's the post administrator. Downwards, thereafter, lordship turned to page 39 notes. Page 39, last paragraph.
Yes.
I hope the lordship will take it.
Yes, I got it.
In the present case, at least though was order reinstated forward or dated 30th January 2004. The lordship can remember that date of the order.
Yes.
But in that order, he is demoted from the post of senior clerk, junior clerk. So the post abused and the post is holding the lots are different. I supported the particular observation of the Supreme Court. The lordship is aware notes. If the permits had abused
The particular position.
the post abused, and thereafter notes
We continue with that post, then only sanction is required. That's what.
yes. But here is a different post, and was only after
Demoted post.
that's in also arguable points not, but the law page 20 para 21 notes and also come to the second
Which is relied upon.
that one.
Which is relied upon.
Exactly. That's what I also knows that. But the important likewise, but alleged misconduct is in some different capacity. I'm placing the law and making line. Likewise, but the alleged misconduct is in different capacity than the one which is still at the time of taking cognizance. There will be no necessity for taking sanction notes. So granting the time notes to raise all those points for. But this is a question of law can be raised notes.
Another matter, this decision matter, the order of this honorable court, order of the Supreme Court.
No, sure.
Once the order was passed, regarding the status of para 16 matter, I have folded.
Yes.
Once the petitioner and is in service.
Now you are reinstated in the lower post. That's the problem.
Reinstatement, but I am in government job.
Government job, but this judgment, honest from says that even if you are reinstated in a lower post and or any other post in a different capacity, then sanction is not required.
The sanction is required. And it says 18 para 16.
See, have you seen the judgment or not? I pass it over. I reject the judgment to deal with it.
Madam, I may pardon one thing, madam. I am giving 3 judgments, madam.
You guys file a written note. I'll pass an order.
Madam,
You also file it.
madam, I pray, madam, one thing, madam. What I am coming to say, madam. Once the order was passed by the any court,
you have 2 difficulties. First difficulty is the judgment. Second difficulty is you have accepted the cognizance order without challenging it. Allow the trial court to proceed. And move the application under 227 for discharge. And discharge order is very exhaustive order relying upon Chotala. Amit Chotara is directly against you. What to do?
Well, I want to clarify, my lord, the once page 16, my lord, this Amar Kumar Behra's case, once the order was passed, that is a nullity if the sanction was taken. Only against me, I am demoted in a lower post. But my, since I am in government service,
But this judgment is.
that see, I pray my one thing, let it come next week.
No, what next week? File taking submission. That's what I'm saying. File taking submission. These are legal issues. What? Why are you not prepared? You should have accepted this question.
I have accepted in sanction 19. I have also come.
We should see a lawyer of your stature should deal with every possible question.
I have.
And when legal issue raised, then you immediately offer it.
For which one? He has time right now. The reason is just given all the judgment except this one.
Exactly. He knows the judgment.
I have record of the section 19.
He knows the judgment.
One had very hard about it.
File it.
Today one thing, madam. Let it come Thursday. I am verifying the source for it.
Okay, Thursday. Okay, Thursday. Thursday. Okay, Thursday. Okay, okay. You take that judgment. Here.
The citation that I must do.
Yes.
85.
85, my lord, welcome matter. The petitioner bail of 18/10/21.
Yes.
21/6/2024.
NBW. Okay. 500. Yes.
It is also matter, my lord. The present petitioners were on bail by additional court in the year 2012 and 13, my lord. Two different petitions.
12 and 14.
And NBW 6
and NBW 6/12/2020. 23. Okay. 500 each. How many of you are there? 500 each. Yes.
87. My lord. Matter, my lord. Very granted on 17/12/2000. And NBW issue, my lord, 11/7/2023.
Bail being?
Bail on 17/12/2000.
17/12/2000. NBW 11/7/2023. 500. Yes.
Not fair, my lord.
Yes.
So modification wrongfully mentioned SDG and Court of Law. That may be correct is SDG Burger.
SDG Burger report. SDG Burger report. Yes.
88.
Yes, sir.
Is a disposed of second appeal.
2006.
First appeal, Lord.
2006.
Regular first appeal, in fact. The arguing counsel who was there on record, he is also here. Therefore, 97 Supreme Court will not stand as a bar for me to place before Lord.
Yes, no problem.
But first point is, the appeal was heard in the absence of the counsel appearing for the respondent. Mr. Tripathi had appeared. He has prepared a written note to place it. On the day it was taken up, the Honorable Court has taken note as if the old erstwhile counsel was appearing and disposed of the matter, in fact. So, first thing is the respondent has not placed the material before the court at the time of hearing. Number two is, the Honorable Court has taken note of one thing, that this agreement of sale is required to be registered.
Yes.
Because possession has been delivered. Your Lordship knows the Registration Act was amended, Orissa Amendment came in 2001. So prior to 2001, on the basis of agreement, possession was delivered.
Yes.
Subsequently, it has been amended. The Honorable Court referred to the prior one,
yes.
And hence it is compulsorily registrable. Therefore, it cannot be accepted as possession has been delivered.
I think second point, you may get a case. When the first point, order 47 doesn't cover you that there. Order 47 doesn't cover you there. In second point you have.
Right. Third point is there, also materials. The parties agreed to pay a further amount. The person who executed the agreement said,
in a specific performance.
yes, pay a further amount. Further agreement. Further agreement means an endorsement in the document itself is sufficient.
Right.
But in furtherance to that, you have paid further amount. Hon'Ble Court thought that further
separate
evidence is executed, in the absence of which the evidence that has been laid by the trial court, that
then that may be an addendum.
Right.
Addendum by way of endorsement.
Correct.
Yes.
So the trial court gave in my favor, appellate court reversed on that ground saying, no, it is not enforceable because you have agreed for a further agreement, but you have not executed. So previous agreement loses its force.
Oh. Issue notice, written resolutions. You have a case. Then these are apparent errors.
Right.
Yes. Issue notice. Huh?
From the other part also.
But these are the material points. That's two material. First point you don't have it.
Right.
First point, I said budget under of the purview of 7.
Right.
But second 2 points, the particularly third point where you say that if there is an addendum, it can't be treated as a fresh. Because the addendum
cannot lose its force.
The addendum is a continuation of the original one.
Right.
It's not a fresh agreement. So that original one agreement will not be closing with something. Yes.
18 hours. Custody since my lord.
2/8/2023. Mother-in-law, your lordship granted bail. This is the first application of the husband.
Yes.
2/8/23. More than a year. Charge sheet submitted by Lord 498.
You have yes.
306.
When are you going to get CD, sir? Get the CD at least. Offenses are
306. 498 and 306. 302. My lord. Charge sheet.
Now,
case of suicidal hanging. Considering that your lordship granted bail to mother-in-law, the petition is the husband. Working inside from the house, he committed suicide. Yes, sir.
Inside the house.
And the statement of one Chandan Das, my lord.
Where is that?
Yes.
Where is that?
Yes, that has not been.
So then,
yes, this is the.
Why you people doing this? I don't know.
It was filed, my lord.
My lord. If you are relying upon something, you must file it, nah? Because these are online things. You throw some paper here. I rely upon it when they pass the judgment, and that
next thing.
that is the whole difficulty. You file it so that even if you is not getting gas diary, I will grant bail. Let's see, you bolted door from inside and committed suicide, and co-accused have been already granted bail. Then he is entitled to bail. 1 year he is only in custody. 23. You file those documents. I rely upon. Next week. Okay, next week. Meanwhile, the civil we call. Yes.
90.
Oh, bless. Call for CD. Okay.
It's a very 11/9/2024 it was disposed of. First application during course of investigation he has approached before your lordship. There in the connected record I have given the reference.
Get
11/9/24.
11/9/24.
24 disposed of.
Just check it up. 11/9/24 connected matter is disposed of. CD must be there. And we know the trick.
Yes. And I used to collect all the CD and exactly.
You know the perfect trick, you know. So therefore you can't seek adjournment after adjournment on this ground.
That understand much better than anybody.
That's what I'm saying. Yes.
Next week.
Wednesday you lost this.
Bless.
91.
Second
This is a second round of litigation also. Lordship has granted liberty to remove the player after
And the 302 dropped and this will be offense under section 498, 30B and 306.
304B. Okay. You are the
Your lordships are on the page 50.
50?
50.
Okay. That time investigation was going on.
no, that time also charge sheet was committed. But because I filed the bail application prior to filing of the charge sheet, the lordship was granted liberty to remove the player in the lower court. So I have again filed the bail petition before the Honorable trial court. Now custody since 1/4/2024.
24. Okay. Okay. Yes. Where is the charge sheet? Show me the charge sheet, sir.
Charge sheet has been filed on 20.
Where is the charge sheet? You show or he?
So I have the charge sheet, my lord. I have not filed.
I'll keep it with you whenever you will file. I'll hear it. Earlier, I rejected your application because charge sheet has already been filed. Go and approach the trial court. Approach the trial court. Trial court is rejected. Now you came here. What is the essential document?
Obviously, charge sheet is
the only essential document. Except charge sheet, you file everything.
Under 302.
Why are you doing all this thing?
So,
you are a young man. You must understand the charge sheet is only basic. Which I have not entertained your petition last time.
Because my lord, I don't need the certified copy. That's the. I understand. I understand.
See, bail petition certified copy is not required. You file it and file an exemption, whatever you want to do it. But this is the only document which is essential.
My lord.
File it, huh? Next week. Okay.
My lord, next week, but not on the 18th, my lord.
Okay. 18th, you know.
92.
कितना बेल मीटर
92 million. That is the offense is triable by magistrate first class. In the meantime, stands on the same footing has been granted bail. Also, your lordship granted another case.
What are the offenses?
457, 380.
How many cases are there?
That is the final 16 cases your lordship granted. Almost all the cases your lordship can see.
Yeah, I asked you to file an affidavit.
Cases I want to file the affidavit. And 3 cases.
21 cases.
I'm solicitor. Your lordship, out of 21 cases, 3 cases were pending before the Supreme Court. In 2 cases, one of them by your lordship and another by co-management by my lordship Aditya Mahapatra. And another case, last case is before your lordship. Your lordship may
what about the other cases?
He has been granted by the law and court below. Because only confession of quotus and interest, nothing else, madam. That is the rejection copy. Your lordship may can see. Another case, your lordship granted there. Madam.
That means in all the cases you are on bail, except this.
Your lordship may can see.
So what to do? You are committing crime after crime. What to do?
Your lordship also concern will apply before the PS because seven except confession statement. He has been remanded each and every case.
So police station, same police station.
Same police station.
Page
10.
The order passed by the
different police station will actually granted.
Yes, and then
careful perusal of the record, I find it. The present applicants are involved in following cases. There's 40.
I know. He says that. I asked him to file. You only tell me in 2 matters this court has granted bail and the court bench has also granted bail. With the condition that he will appear before the IO every time. Okay. For how many months, whatever.
That is there, by the in respect of courts,
on last Sunday, on every month for 6 months. Okay. You just get from the IO the report whether he is appearing or not.
Because I am not the religion bail, my lord. How appear by that is the condition. After religion, I will appear.
Okay.
The court has the power to cancel my bail application.
I'll grant it. Right. Petitioner is accused in so. You were taken into custody in which case?
That is in case of Chandipur case of 56 of 2022. That has been reflected.
The petitioner is accused in age when he was 21. In Chandipur case also, he was taken into custody for approach. When he was in custody, it appears that he has disclosed regarding his involvement in the incident case. Only the petitioner was taken into remand on
19/9, arrested on my pay. That is, I have been remanded on 10/5/2024.
10/5/2024. Remanded 10/5/2024. Mr. Das, and counsel for the petitioner further submits that in all the 21 cases, the petitioner has been granted bail either by this court or by the trial court. But for the custody being continued in the present case, he is not able to be released. Regarding head to the nature of allegation and the period of custody from 10/5/2024, the petitioner is released on bail with a condition. A condition and with an additional condition, he shall appear before the concerned police station every Sunday without fail till the trial of the case is
For a period of 6 months, that is they
6 months. You have to go at least. You should have a watch on you. You will not commit further. That's the idea. Otherwise, that's the case.
Her new matrimonial status, because notice has gone for 98 days.
I don't remember that. I'll just see. Let me run through the list and yes.
As your lordship directed me to make a mention on.
I'll take it up. Yes.
On 411, your lordship was pleased to.
Yes.
53.
May it please your lordship. Pass over 53, my lord. Beg pardon, my lord. I am out of station. In
Yes.
this matter, your lordship, I need to file affidavit. What happened, my lord? In the previous occasion, on 23rd August 2024, may kindly have a glance to the order dated 23rd August, my lord. The petitioners, complainant, and victim are physically present. Yes, my lord. For that reason, a joint affidavit already filed.
Filing affidavit, nothing that.
My lord, joint affidavit already filed, my lord. Your lordship may kindly peruse the order dated AC
By way of last opportunity,
This is also to
one week time is granted for filing necessary affidavit in pursuance to the order dated
AC August.
in accordance with the order dated 23/2024. Please the matter of yes. If you want to continue.
My lord,
Yes.
my lord, for 10 seconds. 23/8/2024 ର ପାରା ନମ୍ବର 5 ଟିକେ ଦେଖିବେ ଆଜ୍ଞା.
It's all right. I've given you do it.
Joint affidavit already filed. Further affidavit I will file, my lord.
Further affidavit. Joint affidavit. Further affidavit. Yes. Yes.
Grateful.
May it please, my lord.
Yes.
There are three matters. Here LMC 240, 241, and 243. All these matters pertain to release of the deposits. The facts leading to the filing of these applications are that the petitioner in the first CRLMC is the accused in a criminal case where he is accused of possession of disproportionate assets beyond his known sources of income.
Yes.
And the case is at the stage of investigation. The investigating agency filled the bank accounts of the petitioner and who is the accused, and of the petitioner in the next application who is his wife, and of that of his son who is the petitioner in the third application. The reasoning that was advanced was that it was one of my salary account who was stopped, which is not permissible under the law. And secondly, as regards the petitioner number 2, the petitioner in the second CRLMC, it was submitted that she is repaying the housing loan, and they had taken housing loan of 86 lakhs, which had been credited to the salary account of the husband, that is the first petitioner, which he again transferred to the account of his wife. And he paid 9 lakhs more to his wife. There was 95 lakhs deposit. And the 9 lakh was paid out of the salary. The statements reveal that. And so far as the petitioner in the third application is concerned, it was submitted that he is a government doctor and the account is his salary account. All the money, all the monies, it was stated that it was his dues he received from the government. And so it had got absolutely no connection with the offense. And accordingly, they prayed, all of them prayed to release the accounts. What the learned trial court did, my lord, is that the learned trial court called for the objection, the show cause from the Vigilance Department. The Vigilance Department did not file any show cause, but submitted that they have no objection if the accounts are released and they are permitted to operate the account. And what the learned trial court 4/1/2024 order is a common order. Yes, common order, the same order. Yes. And the learned trial court further held that the amount lying in the accounts as on the date of house search should be kept at such, and which is also not legally permissible. In this regard, I place reliance on two decisions. One is of the Honorable High Court of Orissa. This Honorable Court reported in 1995, volume 9, OCR 570, wherein in a writ application, come to page 17, what is wrong in it? The wrong is that the court cannot at this stage and looking at the peculiar circumstances, the court cannot direct that the accounts will remain as such. Because the Honorable the account is defrozen. Maintaining frozen, but the amount as on 15/12/2022, which is subject matter of the investigation, that will be not touched. But the fact is that the Honorable Apex Court says that also cannot be done because there is a procedure and we should under the law for
Vice Minister case.
that is not done. No
Investigation is going on.
So far, the Honorable Apex Court says that there is a procedure envisaged under the law for doing that. That is 102. 102 is not the procedure. The Honorable Apex Court says that you must follow the procedure as laid down under the Criminal Law Amendment Ordinance, which is which judgment you are talking about, which is also applicable. 102 trial court, which is also applicable under 102. The court says that you cannot keep the amount, and I am pointing out to your lordship. Your lordship may kindly see section 5, subsection 6, section 3 of Criminal Amendment Act. Section 5, subsection 6 of the PC Act. Lordship may kindly first see section 5, subsection 6 of the. Yes, you have a look. I don't have, but I know the provision. It says that the section 5, section 6. Yes. The provisions of the criminal law amendment ordinance are applicable to the special judge vigilance also. And so, attaching the amount, they need to follow the procedure as envisaged under the law. Without following the procedure, this cannot be done. And that is why the order is bad.
May I clarify, madam? So far as the present petitioner is concerned, it is not maintainable under section 482 of the CRPC because he has challenged the order of 457 passed by the Land Tribunal, which is revisable one. Second aspect is the submission made by the Land Council for the petitioner that it was not objected by the Finance Department, no objection to release. That is not correct. President, I am saying that. Then another aspect is that is whatever submission, whatever judgment they are in, that is relating to attachment and confiscation in section 18A. We are not on attachment and confiscation. We have just seized the account. We have directed the bank to seize the account. And seizure under section 102 is not prohibited. Then investigation is still going on. Still going on. So it's a huge money.
Yes, regarding the 102, which paragraph? Lordship may kindly see the Supreme Court decisions.
Ratan Babu, that is 18A to be followed. That is the step of trigger.
That itself will speak. Yes. The only question which we are examining is whether the attachment of bank account of the appellant is sustainable. It from the beginning.
Okay.
Ratan Babulal Lal.
Yes.
The only leave granted. The only question which we are examining is whether the attachment of bank account of the appellant is sustainable in exercise of powers under section 102 CRPC. The counter affidavit of the respondent seeks to suggest that they are in the process of filing an application under section 18A of the Prevention of Corruption Act 1988, since the earlier authorization issued by the government under section 3 of the Criminal Law Amendment Ordinance 1944 was not in the form of the government order. So that be that as it may, on that account, it is not possible to sustain the freezing of the bank account of the appellant, taking recourse to section 102 CRPC as the Prevention of Corruption Act is a code by itself. In view of the aforesaid position, the freezing of the account of the appellant cannot be sustained and is accordingly set aside.
What is this judgment
of the Odisha High Court? Odisha High Court is also same. It says that under 102 you cannot freeze the account.
No, we are not freezing the account. We are freezing the account.
When the money is kept, it amounts to
no. Where is that out? It's 16 or lots of money. 16. Para 4. Last two lines. Para 2. The bank accounts of the petitioner as well as his spouse falls within the definition proper to 102 CRPC. The IO has vested enough power to seize the bank accounts during the course of investigation and we have seized it.
In the last para,
see a court
in the current case in response.
I know, I've seen it, defreezing. Because the court has
to the
wrong word, that cannot be a ground to release the huge money.
No, but for keeping for attaching the money, they need to follow the procedure.
Let it be investigated. Now your account, you are authorized to do operate the account. But when that amount, investigation is still going on. It is threshold. Let us see the nascent stage. Why should the court will exercise the jurisdiction? Wait for some time. When are you going to file the charge sheet? Say that I have to take that instruction. You seek instruction and tell me.
Lordship, keeping
in case bank guarantee they give you to which also because what is the result of the it's a DA case.
Now you have written 2 crore something.
Okay,
I don't know after investigation. Lordship, Lordship, 2 crore after the 2 crore. I just stated to Lordship that 86 lakh is a loan amount.
See the
and around 30 to 40 lakhs are the dues of the son, and the son is regularly getting the money. Where from I get those things? Getting money from the government. It is
from this petition. Where from I get this?
Lordship, that
suppose I'll have a precondition.
or bank guarantee or indemnity bond, whatever. What will be the amount? How will I arrive at that?
Amount, if lordship says that it is bank guarantee, it must commensurate with the amount.
Account.
Yeah,
Or indemnity bond also, whatever. I need to know
whatever it may.
Let him get the instruction, what the investigation. Can you tell me exactly? So if guarantee or indemnity bond, whatever, we need to know what is the amount involved. If it is 2 crores or less than that, and he says that 86 lakhs rupees he has taken loan, and if that is said to be deducted, it is substantially reduced. That's 31 crores. So it's substantially virtually 50%.
That I
about 1 crore something.
So far as that instruction I'll take, so far as the law point is concerned, we are on seizure and that cannot be restricted.
No, seizure, it is not disputed, but you are attaching the point, we are not permitting somebody to take out the money. It amounts to an attachment, which is not.
Unless after investigation things are clear.
Yes,
nothing can be done. So to begin with, he invoked 102.
Yes, yes.
There is no wrong in it.
Yes.
After investigation, he may follow the procedure established.
Let you take instruction on the point. Lordship said decision would have 1,000 records.
Okay. You just tell me, Mr. Malana, to get instruction regarding the status of the investigation in the cases, in all the cases. Least matter after 2 weeks, least matter. Yes.
38th record, Lordship. 38th as. 38th as.
58. 58.
So matrimonial offense and both parties have they have approved for this family. They want to Vasudeva and wife both are petitioners.
You also one thing?
Informant is wife. Petition number 2. Petition number 2, wife is the informant.
They file joint petition. Yes, ma'am. Joint petition, right now. The instance of incident of petition number 2. FIR number so and so against the petition number 1 has been registered. Well, they are said, yes, they have settled. Staying together.
How come one child has born?
Lordships. Identity proof
आधार कार्ड से करी नहीं जो मोटे स्पेशल आइडेंटिफिकेशन पर फोटो लगेगी देश भाई यू विल आइडेंटिफाई ना यस I have already this man is bringing someone else and exactly my lord. That's why the problem is you have made her as a very you are working now. Very you are working now. That is there. इधर वो फोटो से तो वो देश में वो फाइल वकालत कर है इधर केस में से जना मान लो ये फाइल वकालत नाम ना फॉर इस मीडिया आल्सो आया दैट इज हिज प्रॉब्लम
ये 10 कप टाइम मिलुछ ये फेर ये संग्रह
अच्छा ठीक है एलिगेशन ये तो आप when after investigation charge sheet was filed in this case and the SDGM Jajpur by order dated 27/6/2017 to cognizance of the offence punishable under section 498 capital A /323/506 and 34 IPC.
But 7 is there. 300 should be only. Bruce and messages.
Yes, 307. No, cognizance is
cognizance.
498A, 323, 307, 506, 406, and 34 IPC. Reading section 4 of the DPA. The trial of the case is has already been commenced. At this stage, the parties have settled their dispute. What is this affidavit? Notarized affidavit?
Joint affidavit, my lord. I filed today.
The petitioners, both the petitioners have filed a joint affidavit dated 1/8/2023 24 in and 11/11/2024. 11 inter alia setting agenda. Two
Para 5 to 6.
2 to 6. If it is the second record, 2 to 6. 2 to 6. Both the petitions are present in the court. They are being identified by their advocate, and who has they have also filed the self-attested copies of the Aadhaar card and identity proof, which are taken on record to establish their identity. On the query from the court, the opposite party number 2 has reiterated their stand, as has been mentioned in the affidavit, and stated that they have reviewed the conjugal life, and they are blessed with one son.
Yes, ma'am.
Blessed with one son. He doesn't have any grievance against the petitioner number 1. And regarding head to the facts of the case and the judgment of the Supreme Court in Ganchal, so on, subjecting the petition to figure out the trial will be futile exercise. Therefore, the petition deserves merit. Accordingly, so on, so is quashed. Yes.
66.
On behalf of Mr. Srivat Mumbai, can you take a note?
What is this matter? What are you asking for? Investigation is going on? Huh? It is the ambiguous case. You want quashing of the FIR. Except FIR, you will not file anything. Investigation is still going on. Isn't it? No, investigation might have been over now. 31/10/2023. You have not said anything.
Confessional statement to the ground. That is so by prosper. କିଛି ତ ଦେଇନାହାନ୍ତି ଖାଲି ଏଫଆଇଆର କପି ଦେଇଛି
କିଛି ନାହିଁ for this what kind of petition
to withdraw କରନ୍ତୁ better application
withdraw karo file a better for the petitioner seeks to withdraw this petition to file a better petition with all particulars and relevant documents. Dismiss where with liberty. Yes.
76.
Yes. Now you understood what is that?
Yes.
Yes. Yes. Who is Ravi Narayan Mahapatra? What is he? He is okay. And who is Sai Kumar? He accused.
In one case, the case was already compromised, and now in the present case, the petitioners and the informant,
the cross case
was already compromised, and that is only one.
That is cross case is 11/2015. That is compromised.
Compromised, Annexure 5 is the order.
Annexure 5 is the order. What is that Annexure 5? Okay. And that was filed by the by you against the opposite party. Okay. What are the allegations here?
Allegation 341, 323, 294, 354, 307.
Which is the graver offense?
307. Annexure, your lordship may kindly say
injury report.
Annexure 6 series.
Yes, injury report. I have seen it.
Bruise, laceration, abrasion.
Simple. Okay. Simple. Blunt injury. Object. Blunt object. Simple. Yes. Who are the petitioners?
Petitioners are not accused person. Panchanam Samudra, Bhaskara, and
they are there. Jitendra Bera? Is injured? Is injured or informant? Both.
Informant.
Who is injured? Is injured.
Injured, all the three injured are also present before this court.
Who all are they?
Harmohan Naik and Prafullo Kumar Naik and the informant Jitendra Naik.
Okay. Where is Jitendra Naik? And Harmohan Naik. Okay, clear, injured.
And Prafullo Naik.
Prafullo Naik. I just ask what are the nature of injury. That on the instance of opposite party number 2, FIR number so and so came to register against the petition. The allegation against the petitioner is such and such. Okay. The petitioners, all the 4 petitioners, opposite party number 2, and the injured, namely
Prafullo Naik and Harmohan Naik.
Prafullo Naik and Harmohan Naik are present in the court. They are being represented by their respective counsel and identified by them. They have filed separated copies of their Aadhaar card. Aadhaar card is the Aadhaar card and which are taken on record to establish their identity. Okay. The counsel for the petitioner submits that a cross FIR being Rampur PS case number 11 of 2015 was also registered at the instance of the present petitioner against the opposite party. Which arising out of the same incident. The opposite party and the injured in the instant case filed CRLMC number 2914 of 2024 before this court seeking quashing of the said FIR. By order dated 11/9/2024, the coordinate bench allowed the prayer of the petitioners and quash the FIR number Ranpur PS case number 11 of 2015 and the consequential proceeding arising therefrom. Relying upon the said order, the counsel for the petitioner submits that this being a cross case, the same may be quashed on the basis of the settlement term between the parties. The victim has the informant in the present case has filed informant and the injured have filed separate affidavit before this court on 12/11/2024 in Australia stating as under paraport stating as under the inquiry from the court. So the petitioner, the opposite party number 2 and the victims have reiterated that they have settled their dispute and the cross case has already been quashed, and therefore they have no grievance left against the present petitioners. I have also perused the injury report in the present case. The injury report placed as Annexure 6 to the present petition reveals that the injury sustained by the opposite party number 2 and other injured persons are simple in nature. Regarding head to the terms of settlement and the fact that the cross case registered by the petitioners against the opposite party number 2 and other victim persons have already been quashed. The counsel for the state submits that this court can give indulgence to the present petitioners as there is no legal impediment. Taking into account the facts and circumstances of the present case and the judgment of the Honorable Supreme Court in so and so, subjecting the present petitioners to the rigors of the trial would be a futile exercise. Therefore, the petition deserves merit. Accordingly, FIR number so and so, FIR number 8 Rampur PS case number 10 of 2015 and 10 of 2015 and consequential proceedings arising therefrom are quashed subject to petitioners depositing how much? 307, 4 जन.
Your lordship may thinks.
These 3 people are there. 1,500 each. Okay.
1,000.
1,500. There is a reason behind it. 1,500 each means 6,000 you will pay. Okay. 2,000 you pay. Therefore, I am subject to the petitioners, each petitioner paying 1,500 each to be paid to the 3 victims. 3 victims, the so and so is cost. 1,500 each you pay. Means that the 6,000, 2,000 you pay. Yes.
93. May I please your lordship?
Yes.
I am happy to virtual court. Your lordship, the petitioner is inside the jail since 16th December 2023. The charge sheet was filed on 9th February 2024. Your lordship, in the last order, your lordship had directed me to take instruction regarding the subsequent development while the petitioner was in interim bail, while annexed 3.
Yes.
Your lordship, here the petitioner and the victim was married husband and wife. Your lordship may kindly see page number 191, 121, your lordship. Annex 3. That was the order passed previously. The interim bail application. It was granted for 6 weeks, your lordship.
The same petition. Yes.
So, in the last occasion, your lordship had pointed out in the order, para 5 of the order, page number 125, regarding the petitioner shall be released on bail for a limited period so as to afford him an opportunity to revive his marriage and convince his wife.
Have you married?
Your lordship?
Have you married or not?
Your lordship, the petitioner is a married husband of the victim. And
as per the statement of the victim, in that what are the age reflected in the victims, there is the 18, and in 161 we says that I am the 19.
No, that's right, but the Code bench has given them an opportunity to get married and all these orders are passed. When have you surrender?
Your lordship, already we are married husband and wife. We are already married husband and wife.
You were on an interim bail. When have you surrendered?
You may kindly give some time. So.
Time 6 weeks time was granted to you to marry and report. And have you surrendered or not? That's what I'm asking.
Yes.
You tell me when you surrender.
After expiry of the 6 week, your lordship.
The date. Where is the surrender certificate?
I have not enclosed that, but the petitioner is inside.
I need to know whether you were surrendered or not. Interim bail was granted to you.
Yes.
If you have surrendered, give the surrender certificate. I'll put it next week, okay?
Yes, your lordship.
Okay, next week. Put it next week to place on record the surrender certificate. Yes.
94.
This is the second bail application. First bail application was disposed of by your lordship. The order person is at page 14.
Yes.
Because in pendency of that bail application, charge sheet has been submitted and 302 has been deleted. And lordship was directed to approach before the session judge.
Yes.
But so according to the petitioner, approach before the session judge, but the bail application has been rejected on the ground that
now 304B.
My lord.
Yes.
Since that was 3rd February. 3rd February.
3rd February,
my lord.
Yes. Yes.
My lord, it was rejected on the ground that the chance of influencing a prosecuting witness cannot be ruled out.
You are the husband.
Husband, my lord.
27 years. How your wife died?
Well, died because due to hanging, my lord.
And the Sandhya Kochise, she married the Paradi, that is the allegation. The marriage was a castless, dowryless marriage and organized by Amphoi, that is in the terminal. Because
he is showing some chapter or something, nothing is there on record.
there's a connecting well application.
Where is that?
That I mentioned in the. I can also find it.
Except the order by which the bail application is rejected, you will not place anything. Where from I get?
First in the.
Show me at least evidence, statement of the father-in-law and someone.
Yes, my lord, I will.
Something on record, then how will I decide the application?
Because that was available in another case that is I not.
You get the document and file it 1 week of.
Tomorrow I'll file. That is available with me tomorrow.
You file it next week. Yes. You are only delaying. So how will I come to know what is the
It's a date next week so that I can file tomorrow.
Yes, you must file it. Yes.
Next Tuesday, my lord.
Yes, yes.
95.
Where the new petition has been filed. The original order was reported by the Supreme Court on 16th March 2018.
Yes.
And there is some delay in filing the review application. I have the IA is at tag A.
Tag A.
Tag A.
Yeah.
The delay application for filing the review application.
What are you saying? How are you explaining delay? 2018 you filed the revision when?
2018 was the order passed by the Supreme Court. Against that, I have
2009. 5/11.
November 2019.
Yes. What is the sufficient cause?
500 days.
So many sufficient cause.
Since there is a obligation, instruction from the government, state government, to file the review application. That is paragraph.
Postmaster General.
Yes, that has been.
Surama Manjari.
Yes.
How many judgment I'll tell you?
No, that judgment has been reflected in that.
Where is Surama Manjari?
Yes.
Surama Manjari judge.
In similar case, in Honorable Supreme Court has condoned the delay of 1,101 days.
Show me.
That is page in the review application. 24, page 20.
20?
4.
Yes. 24. Okay. Yes.
In the case of State of Orissa, Ajay Kumar Behera.
Yes.
Leave granted thereafter 25. Delay condom. In that case, this is the SLP so civil evidence so. Having heard the council, having regard to the particular facts.
So this is where the Supreme Court laid down the law on this. I don't know what is the fact of that case. Even fact is not mentioned there in that.
The fact has not been.
In Supreme Court, you know how the rulings are condoned. If you have a if you have a case, then delay may be condoned. You should tell me in the review what do you have. Why are you filing review?
That review include judgment. That page, that is from page 18.
Yes.
This Supreme Court having referred to the various judgments and also postmaster. The last page, relevant page 21. The time consumed in the total process, last time, is stretching for a period of about 2 years. The explanation and the other casual and do not at all appear to be certified. Therefore, testing.
Why don't you challenge this order there in Supreme Court? Rely upon Supreme Court judgment. Why don't you file review? Non-convention of delay by a bench. You are filing a review. What is the apparent error? This is appreciation. According to the coordinate bench, it is not a sufficient cause. How can I say that it is a sufficient cause? Does it come under? No.
That ground has been taken in paragraph.
No, this is It's not coming under the purview of order 47.
16.
You say order 47, does it come under order 47? How? Tell me. You tell me how this petition is coming under order 47. Your FIO is rejected on the ground of delay. Reliance upon Postmaster General, I think so. Yes, Postmaster General. And now subsequent there to Surma Manjari is also there. Surma Manjari is also there. And instead of going to the Superior Court, you have filed the review petition. If I agree with you, then go to the High Court and say wrongly.
That Supreme Court order which I.
Supreme Court, see, this is not a, where is the ratio descending? There is nothing. There is no ratio descending. And sufficient cause is a question of fact, not a question of law. Then?
I am not the entire thing regarding that Asakumar Behra case. Let me allow some time to obtain it.
No, I'll dismiss it. Unnecessary. State is coming under review without filing SLB. You go and file SLB. Reserve judgment. State, first of all, FIO you file delayed. FIO is rejected on the ground of delay. Instead of going to the right court, you are filing review, and that is also delay. What is unnecessarily harassing people? Judgment trigger. That's right. Yes, next.
96. May I please yours?
Well, my lords, the delay is 59 days.
Yes.
And the
delay 59 days.
59 days.
Okay, come to the merits.
My lords. Here, my lords, the consolidation revision filed before the Commissioner Consolidation, my lords, which has remanded to this consolidation officer for adjudication, my lords. Therein, my lords, the consolidation officer allowed my prayer, and the opposite party number 1, my lords, he has preferred appeal. In the appeal, it was confirmed. My lords, thereafter he preferred, my lords, revision. Revision, it was set aside. I have challenged the order of the commissioner before this honorable court.
Where are those orders?
Those are available in the petition, my lords.
No, it's not there in this record. You file those documents.
If
you want to rely upon them.
Here, my lords, so what has been happened in the writ petition, my lords, while the honorable judge setting aside the order of the commissioner, my lords, he has set aside all the orders, my lords. My lords, the order of the consultation officer as well as the appellate authority order and the commission order, which are contrary to, my lords, each other.
No, it is a concurrent finding. Under the principle of merger, all the orders are merged.
No, my lords. CO's order was merged with the appellate order, my lords. Right. Appellate order was set aside by the commissioner. Now, file allowing the writ petition, file the all the orders were set aside. That is the error, my lords. Yes, and another thing, I may be permitted. Another thing, lords, application was filed under section 37, lords, after the consultation period was over, lords. Now, in the input order, it is said that the section 9 application, section 9, lords, applies to the pending proceeding, lords, pending consultation, lords. That is the error, lords.
Yes, Mr. Mishra.
Since there is a delay of 57 days, and I understand that we should file the interim application for confirmation of the report.
Will you oppose 59 days also?
Yes, sir.
And you are seeking, you are seeking 500 days delay, and you want to oppose 59 days also. Forget about delay. They come to the merits.
You are saying then paragraph 6.
There is an apparent error. Apparent error. See at least the coordinate benches, set aside all the orders.
Yes. That is why this quote in the above chapter page 12.
Yes.
Sapara 6.
Yes.
And
This quote.
the constitutional officer remains unjustified in directing the preparation of a MAT and ROR, taking into account the materials available on the record, which information has no specific outcome. Further, the confusion of the CLTD remaining outside domain of the consultation officer. The consultation should have left the matter for undertaking
Appropriate request to both the parties to dismiss in section 9 of.
proceeding. This court here finds all three forums have failed in appreciating this legal aspect and committed illegality. In this order, this court, while interpreting the original order on the same premises, also interpreted in section 9 order as a
that is the ground.
also in the appeal order set aside all. Thus, while dismissing the section 9 proceeding for an impracticable claim involved therein or clear discrepancy in the said deed, this court directs for maintenance of ROR NAR in the position prior to initiation of section 9 proceeding. Parties have however liberty, if so, they may attempt for correction, amendment of the same deed.
There is no section 9 proceeding, my lords. That is the error. There is no section 9 proceeding. Section 9, my lords, applies during the consultation proceeding. Here, my lords, consultation proceeding was over. Section 33.
You have to give me a deadline. How do I know it? Give me a deadline.
Lords,
And find the other orders also.
Lords, writ petition is there. Lords, connected writ petition is there. Writ petition, lords, is there.
You file those documents.
I'll file those.
You file a response. There is something is there. I have to go into that thing. But liberty is of course granted to you.
I'll file those.
Issue notice. Duly condemned. IA number so and so allowed. Duly condemned for the reasons stated in the application. Issue notice on the review petition. Mr. Vishwal accepts notice and seeks time to file response to the petition. Leaves the matter.
So OP1 is a private party, my lords. Private party is there, OP1.
OP1.
My lords.
Take out the notice. Okay. Notice to the private party. Yes.
97.
Yes.
Yes, my lord. Delay was 258 days, my lords. 258 days delay, my lords. And the appellant were the defendant in the trial court. Yes, and against the reversing judgment, the appellant has filed one regular second appeal. That is 108 of 2015, my lords.
Where is the order into?
That's what dismissed for default, my lords.
Where is that order?
That is, my lords. Well, not annexed, that's it.
I asked the same Jyoti. You asked how it is registered. You are challenging an order by which the matter was dismissed in default. That order is not there in the record.
Yes, as the matter.
How do I presume that matter is because you are saying?
No, madam, because the second.
Fundamental thing is the order which, on the basis of which you are challenging, that order needs to be there.
As because the second appeal gets stacked up in the in the review.
I don't know. I am in this petition. Where is that order?
That I will.
Permission. The main record must have come. He should file that one thing.
Why should I run around to find out? Why can't you file there?
I'm only. It's a court of
This is very.
It's a court of record. Now your lordship by virtue of the notification has been placed to make it mandatory that the order.
This is a very common thing. This is not nothing. You will not get those things in the procedural book. This is standard practice. You are challenging an order, that order has to be there. At least for the.
There is also a notification in place that has to be filed. It's also available in your lordship.
That is available in somewhere it must be available. And we have to keep on searching. Where is that?
I just wanted.
But why can't you file? What is the big deal? This much you can't file.
I apologize for that. Thanks for the.
You take out, print out, and file it. Yes.
So on 22/10/2019, the matter was listed. And due to the bar resolution malice,
22/10/2019.
Thereafter, the 22/10/2019, the matter was listed.
Yes.
Thereafter, as none appears malice, and the matter was posted on.
Come to the delay.
Malice.
Why you have delayed it?
Malice, due to malice, we could not ascertain that the matter has been already disposed of by the Honorable Single Judge Malice. That is the whole issue, Malice. It's a mistake on the part of the council, Malice. I admit that.
Pay 1,000 restore to the original file. 1,000. 1,000 to your friend.
Council.
Yes. Subject to paying cost of rupees 5,000 to the opposite party number 1. One or two. All the opposing parties. And, for the stated in the application, convenience of delay in the application is allowed. Delay unknown. The RSA, what is that? RSA, no? RSA 108 also is restored to its original file. Leaves the matter for final disposal.
Cost may kindly be minus I heard minus 1,000. I beg apology, minus kindly cost may kindly be
1,000 only. 1,000 only. You do 1,000 what? Yes.
98.
Sorry.
How many you are coming here? How many you all going to this court?
They committed as well. They were asked to get it from the court room. Whenever they can.
Yes.
Present review application has been filed pursuant to the liberty granted by the Honorable Appeals Court.
Where is that?
Yes, sir. Kindly turn to page 91, last page.
Yes. Yes.
Miss C.K. Sucharita, London Council, I got it.
Now I got it.
London Council plays for liberty to withdraw the special petition as the petitioner should prefer to file a review petition in the High Court.
Yes. Yes, I got it. Yes.
There is some delay, man. You see the tab A, my condemnation of delay application, wherein I have stated.
Yes.
Page 2, para 3, man.
You are appealing for all of them.
My lord, I am appealing for the other party, my lord. Opposite party, my lord. My lord, in the learned Honorable Appeals Court, my lord has directed that the review petition against the writ of appeal, my lord, because the writ petition already confirmed by the division bench, my lord. If the writ petition is confirmed by the division bench, then my lord, review against the writ petition, my lord, how it is maintainable.
Oh, was it they filed against the?
Yes, my lord. That's already been advocated by the coordinate bench, my lord. On coordinate bench, and coordinator is directed to file a withdrawal petition in the previous date, my lord.
This thing you have challenged the order, judgment dated 26/10/2022 passed in a writ appeal. In that SLP, you said you sought the liberty to file review. Then you filed review in the division bench, not the main order.
Can you see again?
Yes.
Honorable Appeals Court order.
Yeah, I've seen it. I've read it.
He also plays for a liberty on the erroneous factual foundation of for the impugn judgment. She also plays for liberty to challenge the order to be passed in the review petition and also the order in the main writ appeal if agreed. If agreed. Then, my lord, in view of such submission.
You are filing the writ appeal, you have to file.
Okay.
Counsel for the petitioner, this review petition is filed against the order dated 15/1/2018 passed in WPC number 19546 of 2016, passed by the learned single judge of this court. The petitioner had assailed the said order by filing writ appeal number. Writ appeal number 198 of 2018. By judgment dated 26/10/2022, the writ appeal has been dismissed by a speaking order. Therefore, the judgment of the single judge has merged with the final order in the writ appeal. The petitioner assailed the judgment dated 26/10/2022 passed in the writ appeal before the Honorable Supreme Court by filing SLP civil number 4115 of 2023. Wide for 23. However, the petitioner withdrew the said special petition, reserving the right to file a review petition. Subsequent thereto, the present petitioners have filed the instant review petition. In fact, the liberty was sought by the petitioner to file review against the impugned judgment before the Honorable Supreme Court. That is the judgment dated 26/10/2022, passed in WA number 108 of 2018. Therefore, the present review petition is misconceived. The petitioner, if so advised, can has liberty to prefer review petition against the judgment of the division bench of the this court dated 26/10/2022 as per the liberty granted by the Honorable Supreme Court. With this observation, the petition is disposed of. Yes.
That liberty part, my lord, if they have come before the honorable court, my lord, knowingly, my lord, then my lord, liberty, that
liberty Supreme Court has given, I can't say, I am repeating that liberty.
Liberty to file review petition against the appeal, my lord, not against the writ, my lord. So
that's what I've said. That's what I've said. Yes.
Okay.
And in section 14 benefit will take it in any case. Yes.
My apology that here also the defect is that order has not.
I know you have argued before the matter is.
I'm praying for a benefit. I'm not praying for a benefit. I am apologizing. This was only for revival. So I have filed a restoration application. So lot of people kindly peruse. The order was to revive. The counsel said he had no instruction. Or dismissed it saying that liberty to revive. I came to know I have prayed for revival. I pray the petition may be revived and may be hard on merit. Revival option was given.
But why will you not file this here? You're supposed to file this.
Anything more?
Now you must tell your instructing counsel to do it properly.
I hope I am telling it not day in, day out, every moment.
Every moment you have to tell them, make them sure that they will file properly. Yes. And there is
delay. Of answering them to be sincere is not going away.
No, they have to be very meticulous in filing. Petitions has to be, all the documents and everything has to be there.
I told them, if you make me free, I can study and I'll do well. If you do ask me to do all these things, then I'm done.
I'll tell you, since morning to evening, I find at least more than 50% petitions are filed without document, without anything. Just casually we file. Yes. What is the interim application?
Revival खाली हो.
He says delay. What is the
delay? Delay I will just say there is no delay in this. The liberty was for revival. It's not a case of restoration. But though I have styled it as a CMFL, but it's a case of revival. I have come out for lordship saying that I am ready to color the case. There was a miscommunication with my lawyer. That much. If I have to file a limitation, I will file by. I cannot contest. But this liberty was given for revival. It's not a case of dismiss or default. It's a case where the counsel didn't have instruction. He said that I don't have any instruction. The court said, all right, this is dismissed with a rider to revival. So if your lordship please know, I have to again go for a limitation also, I'll go for that one.
See, your petition is consisting of 4 pages. Out of 4 pages, 2 pages are cost, I think. Okay? 1 page is Honorable Chief Justice and so and so. And prayer, what you read. How will you make anything out of it? The order is not filed.
Your lordship will kindly see.
We read the petition. Let's read the petition.
Paragraph 2, may I place it, ma'am?
Yes.
The above mentioned case was listed on 19/12/2022. However, due to communication gap, the learned counsel for the petitioner submitted that he has no instruction in the matter. Accordingly, this noble court dismissed the petition for no instructions, however, with a rider of revival. That is the order of the honorable court.
You can't revive there.
I have prayed for revival, ma'am, here.
No.
Petition has come out for revival.
But see, I try to understand this. This has been listed because you have filed that CM appeal. Okay? You have to revive in the writ court. You won't tell that so and revive it.
I have to file this petition, but
you have to file there in the application for revival.
The petition has been dismissed. You have to see my kindly see.
You can do an IA there and saying that you regard my petition. As simple as that.
Will it is dismissed, so that's for the restoration.
Dismiss if it is for non-prosecution, I can restore it.
With a rider of revival, as I understand, subject to correction by your lordship is a restoration also.
No, the problem, the assignment problem is there. Therefore, I am worried.
Once the lordship restores, because restoration is your lordship's assignment.
But here it says that you have to
submit one thing. Once the writ is restored, it has to go through the regular
Yes, what do you say?
Your lordship is not touching on the merit of the writ petition.
No, that's right, but
It's your lordship's assignment which has come.
so it says with the rider to.
If my friend I hope he's for the state, but because the councils have changed, I do not know whether he has survived that councillor. So, but he's for the state. He should have no grievance.
Okay, I'll design like this. By the order dated 19/12/2022, the coordinated bench of this court passed the following order following order in WPC number 11517 of 2010. Next order. Although the petitioner has been given liberty to revive the writ petition, however, the same has been dismissed. Therefore, the present petitioner has preferred the what is that? CMA? Yeah, CMAPL. The present CMAPL. Seeking restoration of the writ petition to its original file, so that on merit it can be decided. Regarding to the submission made by Mr. Sankar Kumar Mishra, the senior counsel, the order dated, I can't set aside also that order. I can recall that. The order dated 19/12/2022 is recalled, and the writ petition number so and so is restored to its original file. Means the matter before the assigned bench for the purpose of hearing. The writ petition on its merit, subject to approval of the Honorable Chief Justice. Yes.
Next.
100.
Discussion 5723 had the list were open. So my assumption that
is there any delay?
No. There is no delay. I have explained in the petition. There is no delay.
Yes. For the reasons stated in the application, the application, the same is allowed. The CRLMC number 1232/2022 is restored to its original file. Release the matter on such.
May I submit? It is a matrimonial matter. I have filed the order of the family judge. 25 lakhs have been paid. And in that picture, it has been written that all the cases should go. In that picture also, this case has been indicated. I say that it is that to class.
No, that matter is not there before me today. What I'll do is I'll list it after 1 week. That matter you give it, each after 1 week I'll give it. Yes. Give it. Restore to original file and list it for disposal on such. Yes.
101.
Yes.
Review petition.
Yes.
Application for review the judgment passed by the Hon'Ble WPC number 8561/2011. This forum 3/11/2042.
Yes.
Lordship, the order is running page 11. Where the Lordship the Vijay Kumar Ratha, the order passed against the Vijay Kumar Ratha, opposite party number 1, deceased.
Yes.
So hence the legal heir of the review petition or Mr. Ajay Kumar Ratha prefer this the Ombuji Ratha Lordship review petition seeks this review.
When he died, Ajay Kumar?
He died on 28/7/2016.
28/7/2016. 16.
Lordship.
Was not brought on record.
Lordship. Brought on record.
And your lawyer appeared why it was not pointed out?
So no one in
2016 he died. When the petition was filed, 2007. Okay. And then when the matter was heard, you were not informed the court.
because the legal heir of the deceased also totally in the dark. No one informed them.
What happened ultimately in the writ petition?
So after the order, this order of this person, the order was placed before the land civil court in Lordship. When the order was placed land civil court, then the petition came to know about the order of the.
No, but the writ petition was allowed in your favor.
Lordship, no Lordship.
Yes, come to the operating part.
Lordship, my paragraph written by brief running plus 5 Lordship. That though the opposite party number 2, namely Sanjay Kumar Rathore, has been allotted a separate land in the village of Baroda Mura and Ajay Rath allotted land separately in the village of.
No, read para 7. The order you challenge is set aside and your writ petition is allowed. Even when you your options. Come to para 7, page 15. The petition was allowed. Your father was the writ petitioner. Even if he has died, it was allowed in his favor.
Father is the opposite party, Lordship.
Ajay Kumar, you said Ajay Kumar.
No, Lordship, opposite party, Lordship.
You say Ajay Kumar, just see Amboj Kumar, you say Ajay Kumar.
Also opposite, Vijay Kumar. This is Vijay Kumar, opposite party number.
You don't know father's name also. You need to read. Issue notice written about also. Mr. Who will accept notice? State? No, private party. Private party. Issue notice. Private party. 2007, writ petition was filed. 2016, he died, and 2022, it was allowed against him. So the LRs have come and saying yes.
100.
Are you sure that
Yes.
your father is Ajay Kumar?
Yes, sir. I have it, Lordship. I have that certificate, Lordship, also.
Okay, I will believe it now.
May I please know? This is an application for restoration of the writ petition. And the legal heir of the British government.
Yes.
The
Where is that order?
case was dismissed for non-prosecution on 16/2/2023. By then, the petitioner had already died. The petitioner died on 17/12/2020. And after that, my lord, the legal heirs could not be brought in record because unfortunately, the lawyer conducting the case for the petitioner also died. The only person who notice which we received from the.
Where is that judgment of the?
This was for non-prosecution.
Where is that order? That is also not there. Where is that judgment of the Supreme Court? And we had the in court. You can't give all the papers here only. You don't file without filing. File away only. Hey, because no, I don't.
The petitioner.
But you have not filed anything, sir. What to do?
Only the order.
Where is that single judge judgment? That is also not there. At least you filed. We have the very message. You started with that sentence.
Yes, sir.
That order is not there. File it. I'll put it after 2 weeks.
2 weeks, sir.
After 2 weeks.
One thing I was telling my the restaurant. Because there are no pictures. Because the order they challenge, they have another order in past. They have to challenge that order now. I have also sought the capture that recent order, 310 matter. So that US order, we have a challenge.
Let him do, and he will
Granted 2 weeks after.
after 2 weeks, but after just 2. File necessary documents.
Yes, sir.
Yes. Yes.
Let's see.
Yes.
On 16/5/23, the case was dismissed for default.
Hmm.
The chairless is dismissed for non-petition, the interim order passed earlier stands vacated.
Where is that?
And the order dated 16/5/2000.
16/5?
16/5/23, paragraph 2.
Paragraph 2.
Paragraph 3.
Show me that order.
I am giving memo, highlight. 16/5/2020.
Where is that order? Just show me. Then how do I know that it is dismissed in default or what on merits? How do I know?
I filed a memo, I have filed on 1/10/2020.
Where is that?
About filed order.
Yes, I got it here.
Non-appeals for the
Yes,
petitioner this year.
for the reasons stated in the application, the CRLMC number 1533 of 2021 is restored to its original file. Leaves the matter for disposal after 2 weeks.
Okay.
Yes. Next.
105.
Set aside and the order dated 16/5/2023 set aside. And file. This is the matter for yes.
May I please, my lord, in this matter, notice has been issued, my lord.
104?
Yes, 5.
25.
Yes. But intentionally, the inspector in charge of Murival police station is not appearing before this court, my lord. Notes is there.
Was there in direction?
Yes, my lord, notice has been issued to
Not
part number 2 and 3.
I am for OP number 3, I am appearing. I am for OP number 3, I am appearing.
You have not filed the requisites.
No, requisites I filed, my lord.
Last time it was,
Yes, ma'am.
last time order is that.
Yes, my lord. Requisites is filed.
For the requisites, requisites in file?
Yes,
Yes,
requisites is there.
Service position.
Notes it has returned, my lord, because the inspector in charge intentionally says not receiving.
3 returned, but 2 not returned.
Not written.
For opposite button number 3, my lord, I am appearing.
Acha. He is already appearing. Who is the inspector in charge?
Yes, sir.
Why is he not appearing?
Lordship, no such, that the letter has been provided to us that the state shall represent. We have received this instruction regarding.
Personal appearance is not required.
There is no such.
You have included therefore notice was issued. What is the matter? Let us see, understand.
Well, this is a matter that present petitioner is a reporter manner, is a journalist manner, and this opposite party number 2 is manner in a forceful manner. She has registered affair. The present petitioner has demolished one of the constructed building, which is constructed inside his premises manner. But it is the opposite party number 2. By harassing the present petitioner and by calling the mother of the present petitioner.
What is the investigation going on?
Yes, ma'am. Investigation is
No. Investigation has already been completed. I can see the prayer made.
I have seen that
The prayer first is annexed to no reason has been stated why it will be passed. Second is my word that to direction may be given to OP number 2 not to arrest the petitioner unless the petitioner has applied for anticipatory bail and it was rejected. That is the matter. Can you see the
you are from the opposite party number 3.
This is the order.
But there's a now you are on anticipatory mal. But the atrocities which is
and the
there is no personal grudge, nothing is there. They are their relatives mal, their brothers mal.
He is on anticipated bail.
Yes, ma'am.
Yes. So that second prayer goes.
Yes, ma'am.
Okay. And now consider the first prayer.
Yes, ma'am.
First prayer investigation is going on.
Yes, ma'am.
Charge sheet file. Charge sheet file.
And I here create for two.
What are the offences in charge sheet? Charge sheet offences.
My charge sheet was submitted under section 427, 506, 294 and 34.
Yes. Now you have to
even
follow the process.
Well, even FIR which I have, my lord, I have given my lord, that is also there, my lord. It's contrary here.
You just
let opposite part number
respect to the remedy.
Well, let the opposite part number to two.
Why should the will come? He is investigating an officer. Why should he be there?
Well, lord, she is harassed like anything, my lord.
You file a case against her.
Personal grounds given the petitioner and IAC cannot be decided on.
How can you say on
You have the petition for that. You have after two prayer. Second prayer is already infructuous.
my lord?
First prayer charge sheet is in file. Nothing survives in this matter. I know. Petitioner has filed the present petition exploring the following reliefs. Relief is good. Insofar as the second prayer is concerned, then counsel for the petitioner submits that it has become infructuous because his ABP number 3174 of 2024 has already been allowed on 10/4/2024 by the coordinate bench. Hence, coordinate bench. Insofar as the prayer number 1 is concerned, now after investigation, now the charge sheet has been filed on.
That's it submitted on matter 23/7/24.
24 for alleged offence under sections
427, 506, 294 and 34 IPC.
34 IPC. Therefore, no interference is called for in this petition. Liberty is granted to the petitioner to resort to the remedy available to him under law. Yes. Yes. Next.
106.
Here I have filed a miscase for extension of the interim order.
Extension of
interim order that is passed on 11/9.
Interim order dated
11/9/2024.
Yes.
Here the brief case is that the opposite party number 2, here is a line at Kolathia where he has constructed his building. Behind his house.
What are you asking for extension?
Interim order.
Which one? Para 7. Interim order dated 11/9/2024.
Yes. That I was disposed of. Let me see the order.
Which interim order you are talking about?
Let me place the interim order. As an interim or measure, yes, para 7 it is directed that on an application being filed by the petitioner seeking adjournment, learned trial court.
No application, who stops you?
That I will dispose of. Now I am also helpless. That I was not there.
But that the order is there. While disposing of that IA, this order was passed.
That is for 8 weeks.
It doesn't say.
For 8 weeks. Period of 8 weeks.
What happened to the main petition?
Main petition notice has been sent, but he has not appeared.
No, you talk about the main petition, whether service is complete justice.
Yes.
No such person resides there.
That is the address given in the 1CC case as well as in charge sheet. That is the first step.
Counsel for the petitioners is directed to take fresh steps to serve opposite party number 2 within 2 weeks. The interim order passed on 11/9/2024 is further extended till next date of hearing. Yes. Next.
107.
Yes.
Let's appeal against conviction. 3 appeals have been tagged together.
Yes.
So far as Subhash Chandra Mishra is concerned, my lords, he is in appeal number 59 of 2011.
Suresh Chandra Mishra.
Suresh Chandra Mishra, Mr. Mukherjee, then senior counsel, has submitted his submission. The rest two appellants, my lords, B.K. Mahapatra and P.L. Barik, they need to submit.
Kunduchan Barik is 13 of 2011.
You are appearing in that
18 of 2018.
Yes. Oh, you hard copy then.
Your Lordship and Suresh Chandra Mishra will be filing a memo of citation of the cases.
Suresh Chandra Mishra में वो ले लेना पहला वाला में. That's first one.
Yes, sir.
First matter. First appeal. That is Suresh
59 of 11.
Mishra. Yes. Written submission you have filed already.
Your Lordship, written submission has been filed.
Yes, yes, sir. Tell me. Come to and who is appealing for appealing the other appeal?
Other appeal
Appeal 13
and 11.
Padmalochan Barik, my lord.
Yes. Who is appealing?
Mr. L. Kannan.
That is the whole difficulty. We can't hear it in two places. One appeal I have heard. Arising out of the same in order.
That's. But from the court side, one pleader has been engaged.
My lords, there are appointed an amicus, my lords. I think he is not appearing. Lordship may kindly.
See, the problem is once you appoint the amicus will come.
That is the difficulty.
Putting the amicus in embarrassing.
Yes, Lordships are correct.
Every time this is happening. What to do? Somebody appeared last time.
Yes.
Mr. G.K. Mishra.
GK.
No. Someone else, my lord.
L. Kannan.
But on G.K. Mishra advocate appeal.
Sanjay Mishra has already been appointed by the court.
Yes, he is the amicus. Mr. Sanjay Mishra is the amicus.
But G.K. Mishra has filed the Wakalatnama. G.K. Mishra, G.N. Mishra and S.C. Sahu.
But some Sanjay Mishra has already placed before your lordship that he has been engaged.
He is also not there.
That is
what to do.
My lords may give one more chance to the amicus, my lords.
Tomorrow, keep it tomorrow.
Yes, it will lie over, my lords. It is there in the weekly list. It will lie over, my lords. This will lie over, my lords.
So that all the three appeals can be heard together. Yes, one appeal I heard, and that hearing will go waste unnecessary. Yes. Next.
In my case, I'm filing the argument on that leader.
Don't give him piecemeal basis, sir. You will give it tomorrow, and I will take it up and just intimate him so that those two appeals can be heard. One appeal I have already heard. Yes.
108.
Weekly list, it should be placed in the supplemental list, then it will be.
In supplemental list. Last item. Yes.
Let's calling this matter tomorrow again.
Tomorrow, when it will come in the supplementary list is the last item.
Can it be next week?
Next week.
Next week.
Next week. Okay. Yes.
May I please? During pendency trial, next week,
Your lordship can I next week supplementary list as but take up a weekly.
During trial, the appellants have waived the lie, and in the constitutional proceeding, my lord has directed to sort out a decision. I'm giving the decision of this coordinate bench. Para 13 months.
Yes. Para 13, yes.
13 months.
Speaking.
Fragment. So towards bottom line, 1, 2, 3, 4, 5, 6, 7. So the natural corollary to this provision is that if there is no possibility of recording any conviction as in the case of death of the person affected and advertisement of the criminal trial against him, a conviction shall not be made
as there is no possibility of the person affected being convicted for the offence under the BC Act. Therefore, if the person affected or the accused is a criminal died and the case abates against him, then the convicted proceeding cannot proceed against the other person in whose name he identified property or money if he amassed by means of the in I have filed the death summary and the page 13 and it's 2 measure.
Yes.
Page 13.
Yes.
Order dated 26/2019, the learned special details filed a copy of death certificate issued by Register by the Court of Municipal certified that the accused Jalandhar Pradhan to have expired on 19/7/2018 as per
Who died out of this Jalandhar?
both have died.
Both have died.
Right.
Okay.
And the trial was facing one Jalandhar Pradhan.
My lord,
Jalandhar Pradhan was facing.
my lord, may I submit one thing, my lords? What has happened in this case? My lords, confiscation order has been passed and appeal was pending. During pendency of the appeal, it was abated due to the death of the main accused, as well as other delinquent, his wife also. Now, the persons, those who have come forward and filed the two IAs, one is under section 394. They were not the delinquent, not the accused persons. They are the son of the
394 is not
applicable. And another is, my lords, kindly see the limitation petition. Only limitation petition, my lords, I am just
yes.
Limitation is 603. IA number 603 of 2021.
Yes.
Just as thrown a paper, my lordship, nothing. How many days delay? What is the explanation? And my lordship, as per their petition, your lordships will find from the petition that main accused has died in the year 2013. His wife died in 2018. And they have admitted that it has come to our knowledge in the year 2019. And the limitation petition, condemnation of delay and the substitution petition has been filed in 2024.
Okay.
It is more than 4,000 days delay and no explanation. And my lordship, your lordships had directed me to come forward with the decisions regarding abatement which has been rejected on the ground of delay. Your lordships will find, my lordship, clear decision, my lordships. It is an inordinate delay, sufficient cause must be shown. And it is a...
This is regarding the conviction.
No, my lordship, it is your lordship.
In a conviction case,
no, my lordship.
394.
My lordship.
These are confiscation proceedings.
Confiscation.
Section 17.
My lordship, what has happened in the decision, my lordship, paragraph 3 may kindly see.
Yes.
At page 389.
During the pendency of the appeal.
During pendency of the appeal, the sole petitioner died. From the record, it appears that no steps were taken to bring on a record the legal representative of the deceased appellant for a considerable period of time, because it has come to their knowledge in 2019. And somewhere on 2010, IA number so and so has been filed, along with IA number praying for condonation of delay in filing the application for bringing the legal heirs on the record. As in evident from the above narrated facts, the appellant died in 2007. And while the present application have been filed on or about 2010, thus there is delay of 778 days delay.
These are different kind of proceedings.
No, my lordship,
these are encounter proceedings.
No, my lordship, principle what has been paragraph 7, my lordship, kindly see.
Order 22 application.
Yes, sir.
How will you draw parallel with order 22 application and 394?
I am not going to that. My principle is it is inordinate delay of 4,000 something.
Maybe this is order 22.
Yes, my lordship, that is true.
We are talking about 394.
Yes, my lordship, and
if there is a stigma, there is a stigma.
Yes,
feeling dies.
And my lordship, once my lordship, it is an inordinate delay, there must be And
See, the idea of 394 is only if the conviction has taken place, he died.
Yes, ma'am.
Suppose.
And
because of the stigma, he can contest it. Get the convict relative or father, whoever it is, acquitted.
Yes.
So the stigma continues till he survives. Where is the question of delay?
Yes, my lordship. And another thing,
whenever it hurts him,
and 394 is not applicable so far as confiscation proceeding.
Imagine a situation, the child was very minor.
Right.
His father was convicted and appeal was pending.
Yes.
But by the time he dies, after attaining 18 or 19 years, when he goes for marriage proposal, and the marriage proposal is rejected, saying that your father is a convict. That time it hurts him. He comes and moves an application at 394. Will you not be allowed?
Yes. Well, so that is under criminal procedure. When that is not applicable,
then when you bring the order 22 principle to say that
principle, my lordship, what has happened? Because several.
No, you just forget that. Now you come to the merit now.
Yes, my lordship 394. My lordship, he has filed 394.
Yes.
Application for substitution. And that is not applicable in this case. My lordship, I will file. I have cited the decision of this honorable court so far as substitution is concerned. It has been.
What is the remedy left here? You suggest the remedy.
That is the gray area, my lordship. That is the.
What is the remedy left?
Because
confiscate the property.
This
even without giving any remedy to him.
Because this is the procedure of the crime, my lordship, which is not cannot be inherited.
But see, the judgment says that if you can't secure the
conviction, so that what has happened in that, because I was arguing that case, my lordship, what has happened, your lordship will find that after death of the main accused during pendency of the trial, we initiated confiscation proceeding.
The other day you are opposing, so you move application section 19 application and all in special court act.
No, my lordship, so far as that present Birajini Ponda perhaps that is yes. I was arguing counsel, my lordship, so far as state is concerned, and in that state, your lordships will find that in the first main accused person died, and it was abated, trial was abated. Thereafter, we initiated the confiscation proceeding. That is why that judgment was passed. That once accused is dead, and thereafter confiscation as it was abated, and there is no final decision in the confiscation as it is initiated after the death of the main accused. So it is not the same case.
But no,
the judicial pronouncement of the confiscation proceeding has been passed by the authorized officer, and it has they have filed
it is pending.
It is pending.
At that time, accused
died in 2013.
Yes.
And another 2018. It has come to their knowledge in 2019, and they filed the petition in 2024. Just 2 paragraphs.
Now, how do you get over this sentence?
My lordship, so far as the limitation is concerned, if the 394, it is 1 month. So it is 4,000 some days delay.
394 1 month.
It is not
1 month is for the purpose of abatement. That means if somebody dies when appeal is pending, within 1 month, if nothing comes on record, it is automatically abated after expiry of 1 month.
Yes.
The life of the appeal remains till 1 month. Yes. After 1 month, it will abate. Yes. But for the setting aside of abatement proceeding, there is no limitation. They can come anytime. Yes. 1 month for the purpose of abatement. After 1 month, it will automatically abate.
And also, my lordship, as my submission, my lordship, 394 is not applicable so far as the Special Court Act is concerned. This is my first submission. Second is, there is no application to set aside the abatement. Because abatement is automatic.
Show me the attachment order. Where is the attachment order? Yes, attachment order. Show me.
Page 37.
30?
And in this case, confiscation has already been implemented, my lords.
37, huh?
The petition filed with state is starts from 36.
36.
The petition filed with state is allowed to contest the passport is described schedule. Offenders are held to the properties acted by working number 1. John the program disproportionate to the non-source of income during the check period illegally and by means of an offence and shall be confiscated to government of Odisha free from all claims so far as the invading properties are concerned, subject to provision. It is further ordered that the opposite shall surrender the property described under the schedule appended to this code within 30 days from the date of service of the pending which the states are taxed for confiscation. The landed property.
And that has already been implemented, madam.
No, confiscation is implemented, but it is always contingent upon the conviction.
Conviction, my lordship, they have died there and
you can't secure conviction now.
No, my lordship, my point is, my lordship, once a judicial pronouncement has been made by the authorized officer and it has been found to be illegal property, and my lordships, in that case, this decision is not applicable.
It is applicable. Can you secure conviction?
No, my lordship.
If the confiscation is contingent upon the conviction, you can't secure conviction, you lose the property.
No.
As simple as that.
My lordship, that is correct. What my thing is,
don't bring technically into it.
Abatement and acquittal.
It is under special court.
Yes, abatement and acquittal are two different things. Abatement means no further proceeding can be done. And person
for the perpetuality you will take the property.
And so far as acquittal is concerned, that offense dies. And in this case, person dies.
No.
Proceeding can proceeded.
Can you use or cure a conviction?
No.
Against a dead person? No. Answer is no.
No.
If you can't secure the conviction,
yes,
the confiscation is contingent upon a conviction only.
My lordship, contingent means my lordship no, but it is my lordship. This is what the judgment. My lordship, starting from Tushar Patel's case.
Let me read it. Let me read the ratio of this judgment. So the natural corollary is the provision is that there is no possibility of recording any conviction as in this case of death of a person effective and abatement of the criminal trial against him. A confiscation cannot be made as there is no possibility of a person affected being convicted for the offence under section PCA.
My lordship, during pendency of the confiscation.
Either it is abated.
Yes.
What he says, either it is abated or it will be not. And death of a person is affected or abated. Since you can't secure conviction, therefore confiscation can't stand. That's what it says.
Yes. And my lord, that is the decision where confiscation order has not been passed. That is the decision. And my lord, as I was arguing that case, my lordship, on the date of pronouncement.
What happened to section 19 then? You can move an application under section 19 now. I'll just give a liberty to him to move application on section 19. Special code then. Let it move on application.
Trial abate kariye. Trial abate kariye.
You can't. My lord, probably that person want to do.
My lordship, another decision is also there. My lordship, I am showing. In that case, my lordship, in the prevention of corruption case, my lordship, the accused dies. And this honorable court, my lordship, just I am. My lords, and moreover, my lordship, this is a proceed of the crime, my lordships. It cannot be inherited, my lords. And the persons, it has come to their knowledge in 2019, they are coming, my lordship, in the year to. My lordship, another decision that is 2002 OLR 242. My lordship, may I read, my lord?
Which section 19?
19.
Yes. Section 19.
Section 19. There is a respondent confiscation model.
Acquittal after death. No. The man doesn't die with stigma unless you prove guilty. No. The presumption of innocence carries. Who the man who dies.
Suppose the person,
unless you record the conviction.
my lord, principle. Suppose the person was convicted And filed appeal.
Conviction is something different.
Yes. And filed appeal.
No, then the presumption of innocence goes. If somebody is facing a trial,
Yes.
during trial he dies. Then he enjoys the presumption of innocence.
Yes.
Because the guilty was not proved.
No.
So that he then therefore he will be treated at par with acquittal.
Yes.
So section 19 will come into play.
Where an order of confiscation, section 15 is modified or annulled by the High Court in appeal, or where the person affected is acquitted by the special.
Acquitted, yes.
My lord, sir.
If you can't secure conviction, it is acquittal. Innocence of presumption of innocence carries with the man who dies. If you otherwise not prove the guilt, what to do?
My lordship, another decision just I am reading out, Honorable Justice L. Mahapatra, my lordship has given in 2002 I am reading out. Prevention of Corruption Act, release of properties attached. No provision in the act on confiscation. The provision of CRPC will apply. Criminal Procedure Code, section 457(2). Property seized and attached on the allegation that accused acquired by illegal means and such properties were disproportionate to the known source of income. Death of the accused. Determination of entitlement only by making inquiry as envisaged in section. And 452, court trying an offence under the Prevention of Corruption Act would have the power to pass an order of confiscation as per the provision contained in the section.
Which section? Special Court Act?
No, my lordship, that is under
Special Court Act is designed for that.
Yes, my lordship, my point is, my lordship.
See, the test in those provisions will not apply in Special Court Act. The confiscation is under Special Court Act. That's the whole difficulty with you.
My lordship,
had it been the normal confiscation, the principle applies.
Yes.
But Special Court Act, the validity of this act was questioned before Supreme Court, and it was upheld. And it says that confiscation is always contingent upon the conviction. Suppose the moment the trial starts, you confiscate, no problem. Once he is acquitted, you have to give it back.
Yes.
But if he dies, what will happen?
Yes.
That means you can't convict him. Therefore, you have to give it back.
And my lordship, so far as confiscation, that Special Court Act is starting from Kishore Patel's case, and thereafter, my lordship, the Brothers case decided by this Honorable Court, and Joginder Jaiswal's case in the Honorable Supreme Court. Everywhere it has been stated that so far as the trial is concerned, it deals with offence, and so far as the confiscation is concerned, it deals with the property, and those are distinct and separate.
You don't.
It is not.
You don't so fight judgment when you say this that.
No, I also my lord.
I don't draw inference from a judgment. Direct judgment, if you have, you tell me. Otherwise, I'll allow you.
My lord, I am trying, my lordship.
It's all right. You get the judgment. But if you don't give, then I'll invoke section 19. Saying that since he has died, he goes with the innocence, he dies, and so it's done. Section 19 can invoke and property you have to.
Also, I may be given chance to research my lordship on the point that abatement and acquittal both. I will.
Special Court, the abatement acquittal will not work.
Yes, I will verify my lordship.
And you tell me.
And more particularly, my lord, so far as the present case, it is what is the bona fide of the present appellants?
That is the second thing. Therefore, I am saying section 19 court will decide, and section
94 they cannot be substituted, my lords. There is no provision, other provisions. Why, my lordship, that statute has given.
You can't render them meaningless. You say section 19 is not applicable. 394 is not applicable.
And, my lordship, that is the.
You can't convict him.
My lordship,
still I will take the property. What is this argument?
My lordship, my point is what is coming to my mind, my lordship. Once a property declares to be a ill-gotten property or stolen property or proceed of the crime by a court, by a judicial court.
Where is it been done? It is only confiscation procedure. Only confiscated.
Yes,
temporary confiscation for your information.
Property is concerned.
That confiscation is contingent upon getting a conviction. Can you get the conviction? Show me the conviction order, take the property. If you can't get an acquittal, you have to conviction, you have to give it back. That's the law. What to do?
And section 19, that is why
That is why it is designed, section 19 is designed.
Once confiscation appeal is nullified or modified.
Nullified or acquitted.
Or acquitted by the.
It has to be returned back.
Yes.
But where is the case, you can't punish him.
Yes.
So therefore, it is equivalent to acquittal, because he died during the trial. If somebody died during the trial, the presumption of innocence goes with him.
Yes.
So then he will be treated as an innocent guy. Because he died. Without permission. He is in a better pedestal than the acquittal. So therefore, section 19 applicable to him. Straight away.
And
he is in a better footing.
And my lordship, that so far as that order of this honorable court is concerned, my lordship, in Sujata, my lordship.
Yes, Sujata. Yes,
this is the case. So what has happened, my lordship? I'm just.
You get whatever judgment you want to get. I'll put it
No, my lordship. Well,
huh? No, I have heard it.
My lordship,
I'll just give 5 minutes to you. Get the direct judgment or order as well.
No, I have to verify, my lordship.
Done
Because this is the case I have.
Very well, no problem. I'll put it on 19 at 3 o'clock.
No, my lordship.
You come with judgment.
So first week of this.
I heard it, I forget.
My lordship, no, my lordship, I will remind you, lordship.
Then let me be on 21st. Let me on 21st. Cut hold of some judgment if you have direct judgment. Otherwise, you don't have a case. Yes.
And I may pardon instead of 21st, 20th.
26.
2020. मैंने फैक्ट्री कंपनी डिसेंबर 20 करना करो काका ना मोट के अच्छी है मैंने
And you have able team. They all of them are no get some judgment. No.
देखे मैंने.
See, these are business pending since 2011.
Situation my lordship. My lordship, because
Property with all respect, my lord. Property will not go. Suppose it is stolen property. If the
don't go with first principle of law. Don't bring circumstance argument. Don't try to.
you also can see the very object of.
You answer me one question. Can you do? No. And how will you treat a person who dies before trial is concluded?
With all respects, your lordship, abatement is not equivalent with conviction.
That principle you apply somewhere else, not in special court.
So for the special court is
no. You show me that. Therefore, I'm giving you time. Give me the judgment. No, I'm not with you. No, I'll go with the principle.
Very object of law is what is the very object of law?
Object of law is to confiscate and obtain a conviction and kill it. If you can't get a conviction, give it. That's the object of law.
That is consequential, na?
So that's you are not able to reach the consequence because you died.
So
honorably
in that case, the person who is claiming the property, he has to satisfy.
That is a different test altogether. Therefore, section 19, you have to move application satisfy the court.
Say the that is a separate.
That is what I'm saying.
Maybe
more application, the trial court will see whether in like that it is not in state. It should be get that back again.
Nice, sir. Next. So far as Ranudala's case is concerned, this honorable division bench, my lords of this honorable court has
you address. Yes.
109.
My lords, first week of December.
No, 20th I got it. This side only one lawyer, that side No, four of you are there and Mr. Das is. Stop there with four guy attacked by 5 people.
Someone is seriously, so that's why we are here.
Yes. Yes. Senior counsel is next time. Experience will do. Yes.
Under 10, my lord. Under 10, my lord. I filed a for a conviction of the sentence, my lord.
stay of conviction of the sentence, my lord. What happened in this case, my lord? The sentence, conviction, my lord.
Conviction, are you appeal?
My lord, under the, it is good case, my lord, for argument, my lord. In fact, my lord, the victim, the petitioner, my lord, working as a, my lord, lady, working as a, my lord, the executive officer of Gram Panchayat, my lord. My lord, the bribe in question, my lord, acceptance and a demand that is not proved against the petitioner.
Then argue on merit, you will go to date.
That may fix, my lord.
Date is there, coming tomorrow, I am free, I will.
So this
Related to Sir, copy, get ready and argue.
Today I will follow.
Yes, sir.
Take out tomorrow.
Yes, sir. If you go for it, then why? It is there in the list only, which you it is remain there. I am not touching it.
Today it is for, you will supply me the copy.
I am not touching it. Let him supply. Let him see tomorrow.
Let him supply.
Yes, yes. 111.
ସେ 111 13 এই ସବୁଥିରେ ମତେ ନବାକୁ ପଡେ ଟିକେ ପେନ୍ ଡ୍ରାଇଭ୍ ନେଇକି I have to go through.
No, pen drive.
Last to
Let him take to the
Stay realization of fine.
ନା ନା ସେଟା ହୁଏ
realization fine.
Stay realization fine.
ଫାଇଲ୍ ଷ୍ଟେ
Another million, another application, stay suspension of conviction. Because you are return now at the age of 70.
Realization fine, which application?
Yes, sir.
realization ଆରମ୍ଭରୁ ହେଇଥିବ ବୋଧେ
ହେଇନି। Call for pay ହୋଇଥିଲା। 8.6.
856.
Up 17 below.
Yes, for the reason stated in the application, the same is allowed. The realization of fine amount so is state.
856
I don't, another application in medical line lot this
I am not passing any order there.
take conviction.
Take conviction is not possible, argue the matter on merit. Yes.
Getting
Consequence is that what is that? Yes.
exceptional cases you not see.
Exceptional case, I am here in proof, but that is the exceptional. Yes. You argue, you ready and argue and Saturday? That year? Working you come?
Yes.
Argue, if you have a good case, argue and get an acquittal and go.
Yes. The target of his life that.
Yes, next.
Well, let's
ଶହେ ବାରଟା
Pension.
ଶହେ ବାରଟା ସେ
So about 113 also. Yes.
Well, it's item number 113. Well, Anil Senior is asking for time alerts. So Lordship will see time and again the matter has been adjourned previously. Also, normally Lordship will fix a particular date and final chance may be given ballots because unending will certainly delayed ballots. Not 114. 112 ballots.
Just now the request of copy.
12 I will say. Swearing deeply swearing. Hearing date is there, weekly list, I am not going to touch it like that. Yes. 115. I was going to.
Acceptance of paper.
Yes. 150.
Paper we accepted.
Yes, 115. 150. I don't think I can hear it today any matter. Any senior is any sorry, 115. Yes. Yeah, 150 is absolutely.
On the ground, in the consolidation operation, the same parties, the will was relied upon, and while the will has been proved also, and it was not disputed, was a tiny mark. Somebody has said it or will give did anything that is presented before the authorities, claiming title and the rest of that, and it has been proved by efficacy, but it has not been disputed by the other side.
Where is that finding? Yes.
Your Worship is referring to the royal court judgment or appellate court judgment?
Show me the interim order where interim judgment.
Right.
Yes. What is that? File है क्या दूसरी?
Yes, sir. If I was so kindly told to Paragraph 6. The submission, the finding information candidate. Yes, page 11. 10 and 11. A suit was filed challenging the findings of the consolidation authority.
10 and page 10.
Yes.
Para?
The 9, if you also begins from 9, it's
yes, 9.
Trial court has recommended finding that
yes,
the said aspect valid of the will is no more open to challenge. This is said in view of the provision contained in section 51 of the Consolidation Act, banking upon it. The challenge in the suit is as regards to execution of the attestation of the said will on the ground that it has not been executed by Mahadevi and is a created one. So it has been subject matter for the Consolidation Authority and it has been accepted and admission is there to that effect. And the trial court also mentioned about it.
Where is the
Consolidation Authority?
Where is that admission?
Sorry?
Where is that admission?
So that judgment is in the trial court record.
Tell me. Show me that admission part.
Para 7.
Yes, para 7 up to the trial court?
Yes.
Yes.
We have challenged the will in this court. I got it. What is 28?
28
of the brief.
28.
20 is the appeal moment. I think the judgment. Judgment.
No. Not there it seems.
Is there? When you have not challenged the same and not produced the document itself, calling the same, leading to secondary evidence with the certified copy of the documents also.
Which para you are reading?
So para 7 level.
Para 7. Para 7 of the
challenge again.
Order and the challenge.
Yes.
Yes.
Order in personal.
Yes.
Last time देखिए पेज 36 लिखी है
36
फाइन मिलता है
6 no the paginations are it's not matching your pagination.
Okay.
Baba 36 is something else. Just check it up your paper book with this paper book. Things are not to be found.
It's not there. I think I also find it.
Yes.
The trial court finding word.
This is not this is a RFA file though. RFA file. No?
Oh, RFA file.
What are you doing?
RFA file.
Review file.
I'm sorry.
Review RFA file.
RFA file.
I'm searching.
I'm sorry. Extremely sorry.
RFA file.
But once the Consolidation Authority gives a finding, so this cannot be subject matter of same challenge for the suit. And if anybody disputed, what would have been different?
Yes.
If contentious is there, Consolidation Authority is not competent to adjudicate.
Yes.
Merit of the will. But the Honorable Single Judge thought that the will was challenged in the Consolidation Authority. It was not.
It was admitted. Otherwise.
Admitted. On admission and proven admission, both.
Who is appealing? Let us issue notice then.
Certainly.
I will issue notice. I have to issue notice. Issue notice to the opposite party number 2, written evidence service estate. Opposite party number 2. Oh, there are many respondents.
Sir, contesting respondent is only Three, in fact. Only 1A, 1B, 1C.
15 respondents.
Others are all pro forma.
But the notice has to be, it can't be moved now.
I'll take
You take out notice, you have
I'll
to
take
take out
notice.
notice, take out notice to all respondents.
I'll take notice.
Yes,
All 15.
3 weeks. Yes. Any urgent mentioning? And the weekly list matter will be taken up tomorrow.
Item 7 is the first matter, the application are not listed. Item 7, first matter.
So I have to go in tomorrow.
Application are not listed.
Item 122. It's a case matter, your lawsuit, how are your lawsuit judgment?
That's there weekly list, 122 weeks. Tomorrow I'll take up.
Arjun, this matter.
I will not take it up. Let it be there. I will not take it up. 120 let it be there. Count for this. I will not take it up.
Item 117. The answer the appointment to I have appeared. Let it come tomorrow, ma'am.
But he is asking for adjournment. There are many matters I can't hear it. In any case, he is asking for adjournment. Let it be there in the list, but I will not take it up tomorrow. One minute.
150 list number. So I am appealing for OP2. So power is given, we accept it.
120, 120. 120. Don't so intend applications for opposite party number 2. 5 to 5 Let it be there. When I will take it up, I will see. There are many matters. Why do you worry? I will not take up the matter. Tomorrow.
Day after tomorrow.
Day after tomorrow.
117 version. This 17 I filed the affidavit version.
Which one?
117.
Let it come. I am not taking up those matters. Matters will be remaining in the board. If you have tomorrow, it reaches. If you have problem, you tell me. I will take it.
So, exact affidavit. And final basis.
Longer agreement, just tell me what it will be long. Just take up the
The case is supposed to prove Lordship in Lord. So, Lordship, it is arguing. Yes, Lordship. I am challenging the discharge order, Lordship.
On discharge.
116 I because I have applied the entire order check because court record has been.
Whoever want an adjournment, you just give this legal. It will be adjourned. Otherwise, it will remain in court.
19 minutes.